Oh.
Ready.
And I think. I wonder if it's cut off the last number. Oh, I didn't come back to oh, yeah, it's all that. 0909. 0909.
Brian, you can go.
I'm ready.
Oh, wait.
Bring a hammer to next time.
Oh, yeah, but I like.
All right, we'll call this meeting to order. This is the State Records Committee, Thursday, March 16th, 2023. And we have 5 hearings today. And the first one is Zimmerman and the Department of Health and Human Services. It's hearing 2022-235. And Zimmerman is requesting access to records about complaints sent in February. So are the parties here in the room or are they online? So come. I'm sorry. You're the respondent. Yes, you're in the right spot. We've been here before. The way that we proceed is each party receives 10 minutes to state their case, present, and we start with the petitioner, and then we'll go to the respondent. There's time in between for the committee to ask clarifying questions. Please feel free to ask us questions if you need to, and then we will come back and allow each party 5 minutes to sum. So, if everyone's okay, we'll proceed. Please state your name.
Judith Kimbrough Zimmerman.
Nice to meet you and welcome.
Thank you.
And
Wayne Thomas for the Department of Health and Human Services.
please go ahead.
Somebody gonna start the clock? There's a clock there. I just need to, it's gonna help me, so, thank you. Okay, thank you for the opportunity today to appeal the Utah Department of Health and Human Services denial of my record request submitted in November of 2022. My record request seeks records surrounding 2 scientific misconduct complaints I submitted to the health department a year ago, involving at least 1 department employee and 2 contractors. At the time of submitting the complaints, I did not receive a response from then Director Nathan Checketts or other health officials. To date, I haven't received even 1 record responsive to this request. To help understand what kind of records might be responsive, I think it would be helpful for the committee to understand the definition of scientific misconduct. Scientific misconduct is often defined as the violation or distortion of the research process or the scientific message by intentional or grossly negligent actions or negligence. In other words, I am interested in records associated with corrupt actions perpetrated by Utah state employees that I am aware of and that have a direct impact on Utahns who are there charged to protect and serve. First, I would like to make a very brief comment on the suggestion by the Utah Attorney General's office that a state judge's decision on a motion in a state civil case involving the University of Utah undercuts my efforts here today with the health department. What the Attorney General's office failed to mention was in that case, the judge made a rare decision to make a default judgment against the university for discovery violations and lying to the court. And what they lied to the court about was records. The attorneys representing the university were from the Utah Attorney General's office. As far as the motion itself, the judge did not believe he had the authority to prove the motion as a remedy. And there's attachment Exhibit A. That said, I don't think there is any question that the health department has the authority to address scientific misconduct complaints involving the department and does have the responsibility to respond to public record requests since these complaints include its employees and the data that it controls. If this case goes to district court as appellate, I would like to preserve the objection that the Attorney General's office is participating as both counsel to the appellee and as counsel to the State Records Committee in violation of UACR 35-1-210. I think it is also important to understand other conflicts of interest that exist in this situation, as the Attorney General's office is providing legal counsel to the defendant, the University of Utah, in my state case that is still open. I would now like to address some of the issues counsel for the Health Department has raised. Counsel has argued that the records I am seeking are not subject to GRAMA because they are records of security measures. Unfortunately, in GRAMA 63G-2-106, see Exhibit B, GRAMA doesn't define this, the term security measures. If you look at 2A through C, clearly those don't apply here. Neither do I believe that 2D would apply in this situation. The security procedures related to the CDC grant activities, which this complaint involves, has previously been made public by the federal government and the Health Department. The Health Department has historically provided copies of security and confidentiality agreements and procedures to parents, health data sources such as Intermountain Healthcare, education sources including principals, parents, teachers, and volunteers. These security and confidentiality procedures are even available on the internet, and parents have a right to know when they have been violated. That leaves 2E. GRAMA unfortunately doesn't define public entity risk assessment or public entity security audit. I'm not sure what these terms mean even after looking at dictionary definitions. I would argue the disputed records do not qualify for records of security measures exemption and is void for vagueness. In an attempt to support my concerns of scientific misconduct, I have provided to the Health Department and this committee numerous examples of records held by the Health Department surrounding this complaint that are in fact public records. Looking at 63-2-301, it states, the list of public records in this section is not exhaustive and should not be limited to access to records. It is my understanding if the committee finds no exemption from GRAMA, the Health Department may just the State Records Committee or the Health Department must justify any non-public classification for the disputed records. My understanding is that as the appellate, I have no burden to disprove Health Department's conclusionary classifications as GRAMA 63-2-302 private records. I also understand the State Records Committee has the authority under 63G-2-502 2B to reclassify disputed records. For the remainder of my time, I would like to focus on why I believe public interest outweighs restriction of access. In other words, I would like the committee to consider the weighing of the various interests and public policies pertinent to the classification and disclosure or non-disclosure and order the disclosure of information properly classified as private, controlled, or protected if public interest favoring access is greater than or equal to the interest favoring restrictions of access. For the record, I am alleging corruption by public employees and officials in the matter of scientific misconduct that undermines the aims and integrity of science and the scientific enterprise. If the Health Department has records to support and or negate those allegations, the public deserves to know the truth. In the handout are two applicable court cases, Exhibit C. Last week, I read a quote in the newspaper from Governor Cox that I think is applicable to this hearing. Cox said, "I believe that trust is the capital of governing people. If people don't trust you, you will never be able to accomplish what you want. If people don't trust the health department, it will not be able to perform its mission. Can you trust the health department when they tell you your minor children's health and education records will be kept confidential and that they are following federal and state privacy laws for the Utah Registry of Autism and Developmental Disabilities, CDC federal grant activities? And I'd like to refer you to Exhibit D. Can you trust the health department will keep their promises when they say, URAD understands and agrees that it is their responsibility. I mean, this is a quote from this record. Quote, URAD understands and agrees that is their responsibility to maintain confidentiality only by releasing aggregate de-identified for all records received under this rule. Is it legal or right when the health department later says it's okay to release URAD identifiers? The following comes from a 2022 police investigation report, which clearly states all of the identifiers if each individual list, I'm sorry, I'm really dizzy right now. All of the identifiers of each individual listed in the registry are shared on the agreement in question, and there's Exhibit E. The official in this police interview, I'm sorry, I can't stop. Ron, could you finish reading this?
Can I get a glass of water or a bottle of water somewhere?
Yeah, I'm just busy. If Ron could just finish reading it, I'm okay. I have vertigo when I get migraines.
Sure.
Could you just, I'm a little better. Okay, sorry.
The department wouldn't object to a short break if needed.
Why don't we pause for?
I would just like to finish
Are you okay?
because I'm not gonna, this dizziness will not get better. So Ron, if you could just finish. Let me turn this direction, maybe it'll help. The police interview was recorded and I obtained that through a grandma request. And what the police interview says is that URAD data was in fact shared with identifiers. Can you start there? Therefore,
Can you trust the health department? Is that where I'm starting?
therefore,
Can you trust the health department when they say that they are using valid and legal data sharing agreements? Exhibit G, when a 2012 agreement doesn't have the necessary signatures, a signature may be forged and another signatory lies about working at the health department as the data custodian. I am personally aware that the real health department employee and data custodian in 2012 has recently discussed with the health department attorneys and top officials his concerns about the validity of the 2012 data sharing agreement, yet health has not disclosed any records related to these concerns. And that's Exhibit H. Can you trust the health department when they say it is not okay? It is okay not to correct data errors in autism study because the CDC said it wasn't significant. Exhibit I, are there any health department records to support or negate that claim? I think it is more than fair to say that statements claiming the CDC is telling state grantees they don't have to correct errors in a multi-million-dollar autism prevalence study is of huge public interest. It was of such interest that two congressmen, one from Utah, Congressman Ben McAdams, and the other from Florida, Congressman William Posey, filed complaints against the CDC and asked them to conduct a scientific misconduct investigation. Congressman Posey was already well known in national autism circles for bringing to light another whistleblower's claims of fraud and data manipulation by the CDC. Posey previously received extensive documentation about research fraud at the CDC from Dr. William Thompson, a senior scientist at the CDC. Claims of research fraud at the CDC by Drs. Thompson and my concerns have some striking similarities. Both Thompson and I reported deviations from predetermined CDC study protocols on key autism studies. Both Thompson and I reported omission of statistically significant data. Both Thompson and I reported that the CDC went to great lengths to cover up research data manipulation. So in summary, I'd like to close with another quote from Governor Cox. Quote, "There's a formula for trust, and that is competency and ethical behavior," unquote. Cox goes on to say that his administration is trying to fix things where that competency falls short, and added, quote, "We have to be ethical, do things in the right way and for the right reasons," unquote. My request therefore directly and completely in the public interest, and is important for the safety and security of those whose information may have been misused by agents of the state and misled by reporting study findings that were manipulated to play down increases in autism prevalence. Thank you for your time.
Yeah. Anything else you'd like to say?
Thank you. So to start out, I was handed some exhibits at the start of this, right before the hearing. And I had not seen these exhibits before. It's my understanding from the letters that were sent out that we were supposed to submit or receive anything with 5 days before the hearing. So I haven't had time to take a very close look at the exhibits A through I that were submitted. But what I can say just from the short time that I've had to look at those, on exhibit A, and I guess I would just have to say I would object to all of those exhibits being entered, but I feel like I have to respond to them. Exhibit A, where it was brought up that the judge said that he had no authority to issue the ruling, I would agree with the judge. I don't think that he did have the authority to issue the relief that Dr. Zimmerman requested. But that said, the circumstances in that case, I won't get into too much depth on that case, but essentially it's there's a legal doctrine called spoliation, and it seems like that's what happened in that case, where the University of Utah was asked through discovery for several records, and when in the middle of trial, one of the witnesses was asked for the agreement that Dr. Zimmerman has talked about. And the witness said, "I do have that agreement. I'm aware of, or I think I know where it is." They went to their office, they found it in a drawer, they brought it back. And the judge said, "You should have given this far sooner than you did. So I'm going to issue a judgment on the merits." And so what that means is the judge is going to assume that Dr. Zimmerman was right about everything she said without it actually being proven. And after issuing that judgment and after the recovery that Dr. Zimmerman received, that she asked to be put back into her job, to have her job back with the University of Utah from 10 years ago, and for the judge to start two separate investigations into conduct. And he said he didn't have the authority for that, and that it wouldn't be just given the circumstances. Anyway, there's also something in one of these exhibits that was brought up about that the statute is void for vagueness. I haven't had a chance to look at the legal citations for that, but I would just generally say the statutes are presumed valid by a judge, and the language I don't see is as vague. If there's no definition of risk assessment or security audit, then you go with the plain language of what those words mean under Utah case law that I could provide if I was given more time. And risk assessment is, I think it's fairly straightforward. And also ALJ Stott, the designee of the CAO who issued his decision below, he found some definitions on risk assessment and security audit that are included in his decision, which is one of the exhibits to the appeal. As far as the argument that the department must justify any classification, the department has justified those classifications as much as possible without discussing private or non-public information in this public hearing or in the brief. And I would also object to any allegations of the department engaging in incompetent or unethical behavior. That's really not for us to litigate here before the State Records Committee. We've been asked to keep our presentation to the subject of records access. So that is what I will. So that's what I'm going to keep the remainder of my remarks to And I'll try to keep this brief to respect your time and allow time for questioning. Any responsive documents are by definition records of security measures that are not subject to GRAMA or subject to release under GRAMA. If they were subject to GRAMA, they would be private records. This means, as I just said, that I cannot describe those documents in my public briefing or presentation without revealing non-public information, which is prohibited by statute. Dr. Zimmerman has explained her interest in responsive documents and why she feels that she, as a member of the public, is entitled to them. But in her request, appeal to the CAO and appeal to this committee, she has yet to present any argument as to why the documents she has requested should be subject to GRAMA and classified as public under GRAMA. She cannot. To summarize the facts that led us here, Dr. Zimmerman submitted a complaint and supplement to that complaint. In her complaint and supplement, she asked the department to take security measures to protect individuals from having their personally identifying information unlawfully disseminated, to investigate the conduct of a department employee, and to take disciplinary action against that employee. Petitioner's request was for records of the follow-up to her complaints, including records of the investigation she asked the department to conduct, records of any findings, and records of any disciplinary action. As explained in my brief, I'm going to go into the security measures part. Dr. Zimmerman's request on its face is a request for documents that are records of security measures. I intentionally refer to them as documents rather than records because they are not subject to GRAMA. The statute is silent on what to do with a request for documents or records that are not subject to GRAMA. To my understanding, the request is not entitled to any rights described under GRAMA, including the right to a response and the right to appeal access denial to the CAO, SRC, or district court. The record is not subject to release because the legislature has determined unequivocally that the records are not to be released or the documents are not to be released under GRAMA, perhaps released under some other applicable state or federal statute, but not GRAMA. For example, in HIPAA, HIPAA is not subject to GRAMA, and HIPAA records may be released under HIPAA. A patient has a right to request them, but it's just not governed by GRAMA. I'm going to share a series of allegations made by Dr. Zimmerman, which show the documents are records of security measures. She alleges that a department employee was involved in conduct that violated the privacy of countless Utah families and put children's personal safety and security at risk, as well as the safety and security of their family members. She alleges that inaccurate information is being published and is creating a public health threat. She alleges that the department is putting individuals' safety and security at risk by sharing children's confidential identifiable records without parental consent and knowledge. This was shared in the briefing and in her statement. Although unproven, if true, these allegations are serious. Any follow-up to those allegations to assess whether they are true and the risk they pose would necessarily be a security measure as described in 63G2-106. That includes results of or data collected from a public entity's risk assessment or security audit. The documents are records of security measures that are not subject to GRAMA. Dr. Zimmerman's arguments support this determination. By her own arguments, any follow-up to her complaint is a security measure. Records of security measures are never subject to release. The point is dispositive and the argument could end there. I'm going to get into the private record part of the argument, but I just wanted to point out records that are private, controlled, other things like that. The committee, even if properly classified, the committee may order their release if the public interest allows it. But records that are not subject to GRAMA, the legislature has not granted that same authority. As far as private records concerning government employees, if the records were subject to GRAMA, they would be private. That is because petitioner's request on its face is also a request for documents that are records concerning a government employee. She asked for disciplinary action against an employee, and now she wants to know what happened. Records concerning government employees are private unless they meet one of the two exceptions listed in 63G2-302-2A. Dr. Zimmerman did not ask for the information described in 63G2-301-2B, so I won't spend time on that, but that's the provision that says, you know, employee's name, compensation, I think gender, and there's a list of things that are public, but that's really not what we're talking about. Dr. Zimmerman did ask for records of investigations into an employee's conduct and records of disciplinary actions against that employee, and those are contemplated in GRAMA. 63G2-302-2B and 63G2-301-30 explain that records of formal charges or disciplinary actions are public if the action has been completed, time periods for appeal have expired, and the charges on which the action were based were sustained. Those circumstances do not apply to the disputed documents. They are not the public records described in 63G2-301-30. If the documents were subject to GRAMA, they would be properly classified as private. For those reasons, they would be properly classified as private, but if somehow the records are subject to grandma because they were not records of security measures and they're private. Private records, as I'm sure the committee is aware, are typically only released to the subject of the records. If I was an employee and employee action was taken against me, even the designation of private doesn't mean that I can't see those as an employee, but it means that another employee or member of the public or somebody else can't, they can request those records, but it would be denied. And Dr. Zimmerman is not asking for her own employment records. Dr. Zimmerman has not shown that she would be entitled to the documents if they were subject to grandma. So that leads us to the next step, which is the committee could order disclosure. So if we jump past those hurdles, if they are subject to grandma, they're properly classified as private, the committee could still release those records if the public interest favoring access is greater than or equal to the interest favoring restriction of access. As I pointed out in the brief, the intent of grandma, the language there discusses that there's a difference between the public interest and the public's interest. So the public may be interested in something, but the public interest could still favor not releasing those records for various reasons considered by the legislature when they enacted the statute. And even then, if the records are properly classified as private and the committee decides to order their disclosure, the committee must consider and where appropriate, limit the requester's use and further disclosure in order to protect privacy interests. I mean, the sections there are cited in the briefing. But the public interest does not favor such relief. As explained in the brief, there are many policy reasons for making records about government employees private unless and until formal disciplinary charges have been brought and sustained. I mentioned two in the brief. The first policy reason is that government entities have an employer-employee relationship. With that comes an interest in confidentially reviewing employee conduct. The legislature recognized that it is in the public interest to incentivize rather than impede ongoing investigations into alleged misconduct. Government employees should be able to governmental entities should be able to scrutinize and examine employee conduct without publicly shaming or embarrassing the employees. This is especially true for investigations into false accusations, complaints made without sufficient evidence, or mistakes or mishaps that do not rise to the level of deserving disciplinary action. If allegations of misconduct are severe enough to merit disciplinary action, charges are brought and sustained, and the time for appealing have expired, then the public has a right to know. The second policy reason is that we live in a country where individuals have a right to privacy and are innocent until proven guilty. Government employees should not have to forfeit those rights. That would make hiring government employees even more difficult, especially in a labor shortage like the one we were experiencing. Although grandma doesn't state specifically the policy reasons behind making these records private, those are two reasons that thinking about the issue logically and working through it, those are two reasons that I presented. There could be many more, but the legislature has struck a balance. Government entities should be able to scrutinize employee conduct, and government entities should have a right to be free from government employees should have a right to be free from needless embarrassment or public shaming. Government employees should be able to work without having their minor mistakes and false or unproven accusations aired publicly. But if an employee is proven guilty of misconduct serious enough to merit and sustain disciplinary action, the public deserves to know, and those records are public under grandma. Petitioner may feel that Mr. Kingsbury is guilty of misconduct and that she personally, as a member of the public, should be able to supervise the department to ensure Mr. Kingsbury is held accountable. But that is not what the legislature decided. By the plain language of grandma, the documents requested are not subject to grandma. Even if they were, by the plain language of statute, petitioner is not entitled to view them, and she has not shown the disclosure would be in the public interest. For those reasons, the department respectfully requests that this committee uphold ALJ Stott's decision and deny petitioner's appeal. Questions for the response?
I have a question. I'm trying to understand. Are you arguing that any records related to employee scientific research is a security issue?
Thank you for the question. So the allegations of employee misconduct, if that's all that it was, is this employee has, I mean, I could throw out any kind of example, but that would be a private record, looking into it, the investigation, all of that. Setting that aside, there's kind of two parts to what she said. She said all of this in her complaints, she alleged all of this misconduct have been occurring, people's lives are being put at risk. People's personal information is being released, which is, personal information is used by, in all sorts of ways to take people to defraud people, to scam people. And so she's alleging that there's this breach, or this data that shouldn't be released is being released. So that is a security issue. So whether a complaint, if somebody were to say, and I don't want to throw, say somebody were to say that there's a security risk downstairs right now, then measures taken to address that risk, even if we don't think that there's an issue, even if it doesn't seem like there's a problem, those are still records of security measures. So that's the first part of this, is her complaint. There's kind of two parts and they're intertwined. There's a government employee that is doing all of these bad things that is a security risk. So looking into that would, and I can't discuss the content of any documents, but looking into that would be records of security measures. So follow-up emails, investigations, anything like that may have occurred.
So the part that you're saying is not covered by grandma is the part that is focused on how you determine whether or not data were released.
Records of security measures are not subject to grandma. And that doesn't mean that they wouldn't be released in other ways. It doesn't mean that they wouldn't be subject to oversight from other governmental entities or anything like that. But it does mean that they're not subject to release under grandma. That's the way that I read 63G2-106.
And is your argument that the totality of those records are that?
Yes, that the totality of the documents would fall under, because necessarily, as Dr. Zimmerman has requested, that security measures be taken. Any security measures taken in response to that would fall under 63G2-106. And the documents are available for the committee's review.
I don't know if you were done. I think we're almost clear that if there was an investigation and the investigation is complete, that, and if disciplinary action is sustained, that records become public. I understand that portions might be not public, but to classify the whole thing as not subject to grandma because security measures were taken to investigate, seems like a stretch to me.
And as I understand, there's three different kind of parts of statute that you've brought up. So records of investigations, that's normally under 63G2 30510, and that's records of investigation. So those are protected. And once the investigation is over, there's case law saying that investigations that doesn't go into the future. That's more of a particular investigation. And then there's also the investigations into employee misconduct. There's some overlap there when there's an investigation, but once the investigation's over, if it didn't result in disciplinary charges being brought, sustained, and the time period for appeal being up, then those are still private. So they're not protected, but they're private. But if they are records of security measures, then they're not subject to grandma. So they wouldn't be subject to release even after the investigation's over and 30510 no longer applies, or even if they're a private record of an employee, the employee wouldn't be able to request those records of security measures.
But you say you have brought records. So we could look at those and decide whether or not they fall under.
Yes, they've been provided. Yeah.
So I have a question. Were there any disciplinary actions?
So there's a statute, and I apologize. I actually included that in a cover letter with the records. But there's two different parts of statute. One is when you're responding to somebody and you describe the records sufficiently enough for them to understand what records have been denied them, unless that would reveal private or protected non-public information under grandma. And there's another part that says that the committee isn't, when they review those records, they're not allowed to discuss that. So it's my understanding that even explaining whether an investigation occurred or not would be describing would be releasing private or information that's not subject to grandma. So I don't feel that I can answer that question, but if the committee asks me to, I guess I don't.
Brian, can I ask a question?
Kind of talk around it. I understand that, and I think we
Can I ask Brian a question? So if the committee as a whole disagrees with, I'm sorry, what's your name?
Blaine Thomas.
With Mr. Thomas's interpretation of grandma, can we move ahead and hire him to reveal information to us that we as a whole believe is subject to grandma?
Yeah, your purview is grandma. I don't know what statute he's referring to on not discussing an investigation. But anything regarding grandma on records, you know, that's your domain.
Well, I don't think we could like ask him to reveal that until we've looked at the records, determined that they're
Well,
subject to.
my problem is I believe that he is incorrectly interpreting 63G2106. Based on the entire context, security measures does not refer to what he is claiming is security measures. So if that were determined, we would not need to see the records. Now, obviously, we may each interpret it differently, but if we did that, we wouldn't need to see the records, right?
Well, because they're saying if they are subject to grandma, they're private. So in order to see if they've been classified correctly, we would have to see the records.
You could do an in-camera.
Oh, yeah,
review.
right. We would have to do an.
No matter what, we're gonna have to look at the record.
Yeah. It is a good question.
So any other questions from the committee? And if not, I would propose we go to the 5-minute, allow the parties to have their 5 minutes.
It isn't there.
Are you okay to proceed, Dr. Zimmerman?
You know, I am very dizzy. I get these dizzy spells, so, you know, I don't have much to add other than, you know, I think you've asked the questions that are important, but I'd also ask you to take a look at the second to the last exhibit. Because this does involve specific employees and other employees saying that they're lying. And I don't see that as a security measure. So I think those types of records would be important to be made public. There's nothing in those records that are going to hurt the security of the public. Thank you.
So I think just as the overarching, just to repeat and summarize, Dr. Zimmerman asked for an investigation into potential breach of information, release of data, potentially people's private information being released in ways that it shouldn't under law. She also made allegations against an employee. So that the department found that responsive documents were records of security measures, and if subject to grandma, they would be private records concerning a government employee, should be no surprise. That's what she asked for. Petitioner is not entitled to access the requested documents. First, as I've said, because they are not subject to grandma, and even if they were subject to grandma, they're private, and petitioner is not entitled to them. I understand that petitioner is interested in viewing and disseminating the documents and believes that the public is interested in seeing them too. But she has failed to demonstrate that her interest in viewing and disseminating the documents outweighs the privacy interests recognized by the legislature when it enacted the statute. In other words, she's interested, she thinks the public's interested, but the public interest does not favor releasing records concerning either documents that aren't subject to grandma or records that are private records concerning a government employee. Rather, the public interest aligns with the plain language of statute. Governmental entities should keep records of security measures confidential and records concerning government employees private unless and until disciplinary charges are brought and sustained. And for the foregoing reasons, petitioner's request for relief should be denied. Thank you for your consideration.
So there are a couple members from the public that would like to speak to this. You okay to just come forward, state your name and
I'll bring it up.
There we go.
Morning, I'm Dr. Ronald Mortensen. I have a PhD. And I'm a retired United States Foreign Service officer and humanitarian. And during my over 30 years of service at United States embassies around the world, I learned just how critically important it is to safeguard the information that we collect on people. This includes even the most mundane personal and medical information. And when systems broke down, I had colleagues targeted and killed. So I'm concerned when I see how much information the state agencies collect on us and how lax they are in protecting that information, except when it comes to letting us know what they have on us, who they are sharing it with, and when that information is misused. This raises safety and security flags for me, and I would argue that it is in the public interest to let us know how the state responds when information security protocols are violated and when our information is misused. As you know, the state collects our private identifiable information both directly when we apply for government services and indirectly by obtaining our information from other sources. This information includes everything required to steal our full identities, to allow perpetrators of child abuse to track their victims, to dox high-profile individuals, and to discriminate against us based on our medical conditions. The Utah Department of Health collects and shares huge amounts of our most sensitive personal and medical information. In many cases, it doesn't tell us that it is collecting these records and why it is collecting them, how our information is used, or who our records are shared with. And parenthetically, it doesn't seem that agencies are complying with 63G 2601, because when I ask, where can I find the statements filed by agencies stating the purpose for which a record series that is designated as private or controlled is collected and used, I learned that most agencies do not provide this information, and it's not available in a central location on the web. So in my opinion, the ideal solution would be for the state to classify all personal information that it collects on us as private, restrict its use to the explicit purpose it is collected for, and prohibit sharing it unless our explicit authorization is obtained. And since this isn't the case, it's imperative that we be told what information the state is holding on us and who it is sharing it with. And the state must be totally transparent in responding to requests for information about data misuse, since this directly affects the safety and security of those whose information has been misused. And it is definitely in the public interest to let us know when agencies are misusing our personal information. Thank you.
Chairman Williams and members of the committee, my name is Kristen Chevrier, and I'm the director of an advocacy group with members across the state that seeks to protect the ability of patients to obtain informed consent and to maintain health data privacy and security. Thank you for giving me a few minutes of your time. We are deeply concerned about the lack of transparency in the Zimmerman versus DHHS case. One of our biggest concerns as a group is the centralizing and sharing of personally identifiable data. The objective of One Bill this session, supported by the One Utah Health Collaborative, was to create a universal electronic medical record. In addition to that, the governor recently issued an executive order on increasing data sharing among agencies. As evidenced by the handout included in this presentation, which is also on your desk, large pools of data encourage large data breaches. Personal health data is not banking information. You can't just change your account number and go on your way. When your health data is stolen or shared, there is no getting it back. Personally identifiable health information has the potential to ruin lives, careers, and tear families apart. We're talking about abortions, children adopted out, sexually transmitted illnesses, rape, incest, depression, psychotropic medications, and so many other health-related issues that ought to be kept securely between doctor and patient. We know that the Utah DHHS receives our data from insurance codes sent to the all-payer database. We know that those records are then shared with the University of Utah for research purposes. What we do not know is where those records go from there, who sees them and in what form. We do know that both the U of U and the Utah DHHS have a history of serious data breaches from the outside. We also believe that they have a history of mishandling personally identifiable data on the inside. Is there evidence of scientific misconduct at the University of Utah? If so, what is the nature of that misconduct? How does it affect the safety and security of our records? As the people whose personal data is at risk, we have a right to know about research fraud, misconduct, improper contracting, or any other corruption within government agencies who are handling our personally identifiable information. We have a right to know where our data is going, who is viewing it, and why they are viewing it. This is public, not non-public information. It's in the public's interest to make it known. Any lack of transparency or stonewalling from our government agencies causes an erosion of public confidence and trust in those agencies and those whose job it is to rein in those agencies. Why is it that the Utah DHHS is unable or unwilling to be responsive to questions about scientific misconduct surrounding this data? You and I and every citizen of Utah has a right to know. Thank you very much.
Further questions from the committee for either party? So hearing none. Deliberation. Or motion.
Move that we go into closed session to review the records.
A motion from Nancy to go into closed session. And a second from Nova. All in favor, say aye. Aye. Any opposed? It's unanimous. We're going to go to a different room and you provided the records to the secretary. Thank you.
Yes.
I'll call it back into open session. And Marie, you have a motion.
Yes, I would like to move that we continue the session, of course, because There is clearly not feeling well and we need to worry about her health. But also because the committee feels like this is a very important decision in terms of what falls under security and what doesn't. And so, and the, excuse me, the respondent was given new information today and not allowed without the opportunity to make his arguments. So for those three reasons, I move that we continue and review it next month.
I would second that.
Okay, so we have a motion to continue and a second from Maria and second from Nancy. All in favor, say aye.
Aye.
Any opposed? Hearing none, we'd like to thank you. So I would suggest that we saunter. So the situations.
Okay,
So.
so we're
please
taking care
your
of
time, the time you need.
Mr. Zimmerman, yeah.
Thank you. I'm sorry. I really.
You're fine.
You're fine. Dr. Zimmerman, I should say.
The next item on the agenda is Tim McConaughey. Yeah. And Jordan School District. It's hearing 2022-220. And the petitioner is requesting access to correspondence maintained in a personal email account. So I think you were here for the prior hearing, but
Yeah,
just restate what we do is you're allowed 20 minutes. The respondent has 20 minutes. There's time for the committee to ask clarifying questions, and then each of you have 5 minutes to sum.
perfect.
So without further ado, please take it
Yeah,
away.
no, thank you very much. My name is Tim McConaughey. I appreciate every one of you being here and, you know, just off the record, you guys handled that really well. And thank you guys for really caring about the people here, you know, so that's very commendable. So thank you very much. Now back to business. So I guess why am I here? I'm asking to get records from Jordan School District. And this all started in an email that I reviewed from Board Member Robinson on September 20th, 2022, where Board Member Robinson threatened to take revenge votes against West Jordan Elementary. He also stated that he would struggle making objective decisions regarding West Jordan. And so this prompted me to see what we could do to look at the records and, you know, is this just a threat or is there something really going on here? And so that's why on September 28th, 2022, a GRAMA request was submitted. In that GRAMA request, it was denied by the Jordan School District because the Jordan School District does not maintain emails from this address, drdarrellrobinson@gmail.com. Therefore, no records. We have no records responsive to this request is invalid. So I went through the appeal on that, and I did not hear anything back from the district. They let the time lapse go. The reason why this one should be approved is there are multiple government entities that have tried and failed to cite 63G2 10322 AI to deny access to messages on personal devices or personal email accounts. In these cases, the State Record Committee decided that it was not an appropriate interpretation of the statute. And I have more information here that kind of cites stuff that cites those if needed. And that was actually in my message to the Jordan School District. So in the case of Kim Henderson versus San Juan County and Mark Allen versus Utah County goes into that. And so I'm requesting that you know, case be relooked at and I can get the records for that request. There was another subsequent GRAMA request filed on October 17th, 2022. And this one was partially fulfilled. We were provided with 7 emails and 2 text messages, which were for 2 years. The request was for 2 years dealing with financial information for schools in Riverton, Harriman, and West Jordan Elementary. The reason for this is there have been public comments on Board Member Robinson's Facebook page of his constituents in his districts asking for the $1.5 million in savings from West Jordan Elementary to then be put into programs that are in his area there. I know that there are more than 7 emails and 2 messages that happened over the span of 2 years. Board Member Robinson has commented on financial matters in public meetings. The board has to have that information. And we can go through and do more GRAMA requests in order to get that information, but it's there. In the response from Jordan District in the letter that they sent out just 5 days prior on page 2, it says on October 21st, 2022, the district provided the responsive records in its possession, including the personal records provided by Board Member Robinson to Mr. McConaughey. Board Member Robinson informed the district that his typical practice is to not retain records of communication and therefore frequently deletes his old messages, but he was providing all the records he could find. So we have a board member who is going through and deleting messages that deal with the district. I have one right here, and it just so happened that my wife sent a message on July 26, 2022 to Board Member Robinson, talking about financial issues with the district, and it should have come up in the self-reported search that Board Member Robinson should have had. So I don't know if you guys want to see this or if this was included on your information, but I have it right here. And it was not provided as one of the 7 messages and 2 text messages. So that's a record that was missing. So why are there government records in Dr. or Daryl Robinson's personal email address? The Jordan School District lists Dr. Daryl Robinson's personal email and phone number on the official website. This is the address that Board Member Robinson requests that people contact him by. He's the only one that does not have a jordandistrict.org. And so why is the school district responsible for the records? They're responsible because the Jordan School District's record retention policy, he still has to abide by that. Even if he has his own personal email, he still needs to do that. And the district has not abided by the record retention policy or has held their board members accountable for that. It's saying here, DP 36.7 district records management, section K says retention of district records. The district shall adhere to the general schedule for records retention approved by the State Records Committee, and 2 records are not covered by the general schedule shall be submitted to the State Records Committee for scheduling. So they default to what the State Records Committee says and states. Also on the website for Jordan School District, there's a training for each member, and it's policy.jordandistrict.org, and I can show it to you if you want, but that states that each member is trained on what the retention policy is and how to handle things. Member Robinson has been on the board for over 6 years, and the policy has been in effect since 4/23/13 and consistently revised. So all board members have been trained on this. So in conclusion, the record should be granted to comply with state law. Checks and balances are in place to ensure that board member Robinson and other school district members are acting ethically without any behind closed door decisions. The Jordan School District needs to put an end to fostering an environment of unaccountability by allowing board members to delete emails and not enforcing the record retention policy. Thank you.
Questions for petitioner? Okay.
Thank you. Can you hear me all right?
You can. Please go ahead.
Hi, my name is Paul Van Coleman. I'm here on behalf of the Jordan School District. And I just want to begin with, there's a big distinction between an employee of a governmental entity, an employee of the school district in this case, and an elected official. And that's both in the law and by statute. And the Government Records Access Act specifically deals with records that are maintained by the governmental entity. It includes in its definition the term elected official and defines elected official. Mr. Robinson, as a board member, is one of 7 board members who is an elected official. Clearly, in this case, any records that the district had, including those records which it asked Mr. Robinson, his privately owned email records, which were provided to them. Once they had those records, those were provided. And this is very important because the district recognizes that there are statements of intent by the legislature, including that records generally are to be made available. But this is really a matter of statutory instruction. The legislature has specified what is a record, which records are required to be given, and who's required to respond to GRAMA and who's within the purview of GRAMA. And unless the records fall within the definition of a record and become a record created, maintained by the school district, they're not subject to GRAMA. Mr. McHoney, understandably, has issues, and he can take issue with how Mr. Robinson or others deal with their own personal records. But GRAMA doesn't enforce the district to require one of its elected officials to do something outside of GRAMA. It's just not within their control. It's not statutorily authorized. Had the legislature desired to empower a school district or other governmental entity to do that, it clearly could have provided that in the act or in a separate act. Mr. McConaughey has pointed to nothing that authorizes the district to take the action that he's asking for. I want to go through those citations. They're included in my brief, but elected official means that each person elected to a state office, county office, municipal office, school board, or school district office. It's clear that an elected official is different from an employee. Governmental entity means any political subdivision of the state. And that includes the school district in this matter. The Governmental Records Act also includes as a defined term, the term individual. And that is, individual means a human being. That comes into play here. Clearly in subsection 21 of definition section 103, public record is defined, but that relies on subsection 22A. And again, record means a book, letter, document, paper, map, plan, photograph, film, card, tape, recording, electronic data, or other documentary material, regardless of physical form or characteristics. And then subsection 1, that is prepared, owned, received, or retained by a governmental entity or political subdivision. It does not include an elected official as that term is defined. In addition, records, the Act goes on to define what are not records. And in subsection B, I've referred to subsection B, subsection 3, and it says material that is legally owned by an individual in the individual's private capacity. And that's what happens here. Mr. Robinson is the individual who owns the access to the emails on his personal email server. Those are not in the possession. Those aren't prepared, owned, or received by the governmental entity. Those remain his individual capacity. And this is important because there's some confusion in record B because, and I didn't include this, but subsection 1 says record does not mean a personal note or personal communication prepared or received by an employee or officer of a governmental entity in a capacity other than the employee's or officer's governmental capacity, or that is unrelated to the conduct of the public business. Now, this is not saying that something that is owned by the individual simply because it's related to the public's business is subsumed into a government record. This provision was added when the legislature specifically addressed concerns saying, well, what about emails in this case, on a district email server that really have nothing to do with the person's governmental capacity? We clearly received it. We clearly own the record, but it's not related to the public business. You know, somebody who is getting messages from their child, those sorts of things. That's what it's saying. Even though that is maintained on the district's email server, and even though that person is a governmental employee or officer, in those cases, if it's unrelated to the conduct of the public's business, it's still not a record. That doesn't mean that something that is not defined within the broader definition of record excuse me, what that doesn't do is it doesn't say anything related to the conduct of a public's business is somehow a record. GRAMA just doesn't go that far. And in fact, that would be contrary to well-established principles of statutory construction. You know, it's well established that courts presume that the legislature used each word advisedly, and they read each term according to its ordinary and accepted meaning. And wherever possible, they give effect to every word of a statute, avoiding any interpretation which renders part or words in a statute inoperative or superfluous. So this really does boil down to under GRAMA, privately maintained, owned records, just because you're a governmental employee, or excuse me, because you're a governmental official, they don't become records of the governmental entity themselves. I use as an example, if somebody is given information in an email, and they subsequently talk about it in an open meeting, it doesn't make that suddenly the actual record a public record. Neither does an individually owned book given to a teacher, individually, not to the school for the teacher to then access, but say a patron gives a teacher a book, and it's because she or he is the classroom teacher, and this patron says, I think that you'd benefit from this. Even if they use material from that in their class, if it's privately owned, it's not a public record. There's been some discussion about the district lists Mr. Robinson's email on its webpage. That is because that information, the email address, is a public record, and the district is required to provide that. But it is not required to provide the email for that individual. That is neither in the Access to Elected Officials Act or in GRAMA itself. Nothing requires an elected official to use the governmental entity's email service, thus making it an email a public record. Now, what remedies does a disgruntled public have? Certainly they can go to the public and say, we don't think that this individual is transparent, or we think that this individual should be voted out of office, but that's their remedy. It's through the ballot box. It's not that GRAMA authorizes them to get records which are not otherwise designated as records. The distinction between employees and elected officials is important, and that's recognized in the Public Officers and Employees Ethics Act. Section 67-16(3) has those definitions, making the clear distinction between a public employee and a public officer or elected official. It's easy to just assume that because an individual is somehow associated with the school district, that somehow everything that they own or have, or everything that they do, and every action that they conduct is binding on the district. Board members are not authorized to speak on behalf of the board as a unit, or to speak on behalf of the district. Action is taken collectively, as this body would know, by a majority, or in some instances a supermajority, as required by law. In the same way, public officials or elected officials have greater free speech rights than an ordinary employee of the district. As an elected official, the school district cannot impose restrictions on them like they can generally an employee. The same way they can't impose certain requirements of conduct as an employee is subject to. So it really is, it's understandable that people say, hey, an elected official, we contacted them about something and it's a matter of public concern. But if it's not a record, there's nothing that the school district can do to require that individual to create it. In this case, the district asked Mr. Robinson to comply. he has indicated his practice is that he does not keep his emails. He's not subject to the district's retention policy because he is not a governmental entity subject to the government retention of a governmental record. Again, notably, GRAMA also requires that a public record is of the community council members' email addresses. And the district complies and provides those out. But to suggest that every community council member's private emails, because they don't maintain those on the district web, email service, to assume that they're private simply because something may relate to their duties as a community council service. Again, that's outside the purview of GRAMA, but it's the same analysis that is trying to be used to say a board member has to provide the records. There have been no records that the district received or had that have not been provided. And the position of the district is this is legislative. This isn't, if the legislature wants to expand GRAMA to include elected officials' communications simply because they relate to the business, whether or not they're the governmental entity has any control over those in creating, receiving, storing, et cetera. That's legislative. That's not for the district to decide. It doesn't have the power to do that. It can ask. That's what it did in this place, but it can't require. With that, I mean, I can address the procedural issues, but I think we're here. It's not really that there was a GRAMA request initially denied. That's what the portal indicated. When the district responded, we have no records that are responsive. That was a response. When clarification was sought through email correspondence with the records officer, there was some additional follow-up, and before the appeal time, even though there was not necessarily a formal right to appeal because there hadn't been a formal denial, the second request, which clarified that they were after the Daryl Robinson emails, those were provided, and Superintendent Godfrey did respond, indicating that the district didn't have any of those records, but it went ahead and asked for and provided those. So I don't think that this is really a procedural matter, but there's an explanation for that. We're here in good faith. The district doesn't have any records to provide that it can give. So with that, I'll turn the time back over for questions or for Mr. McConaughey.
Thank you. Any questions for the respondent?
I have a question. So the other 6 elected board members who have the jordandistrict.org email, those are maintained on the district's server, and those are managed through the district, correct?
Correct, and the district responds when people ask for those records.
Okay, so what was his name? Dr.
Daryl Robinson.
Daryl Robinson, he uses his gmail.com email, and it's listed on the Jordan District website. And he is doing the public's business with that email. Do you not believe that it should be subjected to GRAMA as well? If he's doing the public's business?
GRAMA does not extend anything that is done under the public's business to be a record. That's just an overextension of the actual statutory definitions. It may be good policy, but again, GRAMA doesn't empower the governmental entity to take and require any elected official to conduct its communications through the district or through the governmental entity. The legislature could also make that clear if that's what they intend. It's within their purview. you know, these issues have been around for a while. The legislature just simply hasn't taken it up to make those clarifications at this point.
Any other questions?
So, as a hypothetical, if this records requests were made not to the school district, but to the Jordan District Board of Education, how would it be treated differently?
Individual board members are not a governmental entity. So the body as a whole, what the body keeps, what the body receives as a whole, it does that through the district. But again, the individual members are not employees of the Jordan School Board.
Yeah, but what I'm asking, is the Board of Education, the Jordan Jordan School District Board of Education, a separate entity from the school
From the
district?
school district. The board is a body politic. It's not an individual member. It's not any of the individual members. So the board is essentially the Jordan School District. That's correct. But Mr. Robinson is not.
I feel
That's
like,
not what I was asking. Go ahead.
I feel like I'm not sure arguments is the right word, your your position is that, I mean, if you look at OPMA, the Board of Education is subject to OPMA, which is doing the people's business in the open. There's only a few exceptions that you can close a meeting for. Why would grandma be any different? That is, that you would need to conduct the public's business in open, meaning that those records would be subject to disclosure if they have to do with the public's business. I mean, the legislative intent of the act is to recognize that constitutional right, that the public's right of access to information concerning the conduct of the public's business is just that, a constitutional right.
First of all, the Open and Public Meetings Act is separate from GRAMA. While they may be related, nothing in the Open and Public Meetings Act creates a definition that is applicable to GRAMA. The broad statement that there's a constitutional right for things to be accessible is stated in both of those, but in GRAMA, it's then defined specifically by, so what are we saying is the right to access? And again, it's not records of the individual board members or elected officials.
I just don't.
You
see where
can't take the
grandma
broad
is.
statement and you can't take the broad statement and assume everything. In the same way, you can't use the same analysis under statutory interpretation principles to say, well, a board member is an employee of the district. That's just not accurate from the sense of what a board member's duties and powers enable it to do.
I understand that elected official is defined in GRAMA, but I don't know of anywhere in GRAMA that it exempts an elected official from disclosing records that are in the public's business.
Records of an elected official, if they are within the definition of record, and that again comes back to, does the actual governmental entity create or maintain or receive those records? Then yeah, simply because you're an elected official, those aren't somehow exempted. But until it becomes a record of the governmental entity, I know it seems circular, but it doesn't say elected officials have the same obligations or duties to provide something simply because of their position as an elected official.
The board members are over the budget for the Jordan School District, correct?
collectively,
Thank you.
but not individual. An individual can make, individual board member can make statements, can take positions that may not be the position that is ultimately adopted by the board and binding on the district.
Any other questions?
Yeah, as far as is what information is available, certainly the district hasn't withheld record information or budget information. That's all up on its public websites. That access is available if somebody asks for underlying information. The district provides that and does do that. It simply just doesn't have the communications of a board member outside of what it maintains and receives.
Okay, so any further questions for the respondent? Hearing none, we'll go back to the petitioner. Yeah.
Okay, perfect. I just want to let you know that I did file another grandma request to get information from the school boards, from the head of the school board on Dr. Darrell Robinson, and the school board was able to provide a lot of information. They said it was there. Here's your fee you're going to have to pay. So it's obviously holding Darrell Robinson to a different standard that they're holding the rest of the folks to. I just want to point out in the case of Elias current class versus Lehigh City, the requester sought access to work-related images or messages from a city council member, regardless of whether it was from a personal or government issued email. The State Records Committee decided these messages should be considered records under GRAMA and they should be disclosed if they concern the public's business. I'm not asking for any information that's personal to board member Robinson. I'm just asking for what, the records that are provided and that GRAMA has for other elected officials. He should not be treated any different than any other city council member, any other board member. I do believe Jordan School District pays his wage. And so I believe that these records should be made public. So I think that's all that I have here.
Thank you. Back to Mr. Van Komen.
Again, I'm familiar with the committee's prior opinions, and again, I just want to emphasize the district doesn't have anything that it's withholding. I think what Mr. McConaughey is after is to subject Mr. Robinson to, for example, the retention plans, et cetera, that the district has. The district has no control over what he receives or doesn't receive, or how he deals with his private communications. Until the legislature empowers the district or requires an elected official, legislature could easily say, as an elected official, you have to use an email account that goes through your governmental entity. There are lots of ways the legislature could bring to effect what Mr. McConaughey wants, but it hasn't done that. And so to just say, well, the district could require Mr. Robinson, he's held to a different standard. The district doesn't have the authority to subject its elected officials to this. It asks, it volunteers, it provides, but we're unaware of anything in GRAMA that requires the district to make Mr. Robinson use its own email. So that's really what the issue is here. What Mr. Robinson does outside as an individual, that's under his purview, and it's not under the control of the district. I know that that's maybe not a popular position, but from a legal standpoint, I think that's the correct interpretation. Until the legislature says otherwise, under the statutory construction that we use for all statutes, not just GRAMA, unless we can find something specifically that says each elected official, private communications, information that they have outside, it's never within the control created by the entity itself. GRAMA says, an elected official, it knows, it recognizes the difference between the elected official itself and the actual governmental entity. And it's the records of the governmental entity, not the elected official, that are subject to the provisions of GRAMA.
Thank you. We have a question.
So just so I'm clear, the school district's position is that these emails on Mr. Robinson's personal email account are not a record under GRAMA, but as a courtesy to the petitioner, you went ahead and requested them anyway. Mr. Robinson gave you back and told you that's all he had, and you forwarded those on to the petitioner. Is that correct? Is that how it happened?
I think that's a correct summation, yes.
Okay.
Thank you. Any other questions? Okay, we'll move to deliberation. I'd like to begin.
I've been looking for it. We had a similar case with the Salt Lake City School Board last year. Remember that? There was a request of the emails of a board. And didn't we say? Yeah,
Yes.
Well, yeah, I remember the Mark Allen case too. That was a county commissioner.
right, but this is, the thing
An
is that the
elected
Salt,
official.
yeah, but this is also a Salt Lakes. I mean, this is a school board, so
Yeah.
we've already made that decision.
So Brian, do you agree with Mr. Van Komen? I can't find a citation, but it seems to me that it has been determined that under GRAMA, personal emails conducting the public's business are subject to GRAMA.
I really can't answer to his position. I
Okay,
can
but-
guide you on interpretation of statute for your sake, but not.
Okay, well, for my sake, does GRAMA? I can't find it,
Well, the
but
state records committee has determined that it does in the past.
there isn't a citation in GRAMA that allows for emails, private emails of an elected official that conducts the public's business to be subject to the act.
Well, I
I
think.
thought there was a
Well, I
citation, but I
think
can't
the-
find one.
Yeah, I think the legislative intent determines that.
So that's how it's been determined. There isn't actually. a
Yeah,
piece.
if it's the public's business. Now, we had a case last month where we looked at emails that they claimed were personal and made a determination that they were personal, so they weren't
Yeah.
public business.
Yeah.
Right, but if it's conducting the people's business, we've consistently supported, whether it was on a city email system or a governmental entity email system or a personal email system, they were subject to GRAMA and retention. Given that they're conducting the city's business, or I'd say, sorry, I go for city,
Yeah,
a governmental entity's business. I mean,
but
we've been-
retention also.
that's
the-
kind of, that's been our, that they're subject to retention. They need to,
Okay.
they don't have to use the state's retention. They can create their own and then report it to the state archives, because communication under the state archives recommendation is a permanent retention. So not all entities believe that those emails should be kept permanently, and some of them have created their own policies that don't keep them permanently. But I think if they're conducting, my opinion is, if they're conducting the city's, governmental entity business, it's owned by the governmental entity.
The email, the
That's
specific
my
email.
opinion. Regardless of what.
And
system.
especially that he's using it on their website.
Yeah, that only.
Yeah, he's not providing an alternative.
Well, that's the problem. We can't tell the district, you failed because, and that's their argument. Well, it wasn't us, it was Robinson. But we need to send a message that Robinson needs to change his behavior, I think.
Well, and the district needs to change their behavior. This is really poor records management.
Yeah,
Well, and all of the other 6 elected officials have a jordandistrict.org email, but his Gmail is on the website like we were talking about. And to me, he has provided that to the public to do the public's business, and therefore it should be governed under grandma.
And he should be keeping those records and not deleting them.
Exactly. Now, the petitioner could probably request emails from one of the other elected officials that the server on the Jordan District server maintains. And you probably get an email from.
And I fully support that a personal email is not, shouldn't be, doesn't fall under being released. I mean, we ruled that just last month. But when it has to do with people's business, yeah, I have a hard time with the argument that the elected officials are exempt from that. To me, they have a higher, even a higher standard to meet to be transparent. And that's why I brought up OPMA, because OPMA supports that higher level of transparency for elected officials.
Yeah, but the reality is the practice, I've encountered this many times. From a city level to a school district, and other entities where the entity gives the person the option. And when they take it, the governmental entity does not bind them to any kind of retention. This,
Right.
what Jordan
It-
School
it
District,
is.
what Jordan School District is doing is common across the state
Yes,
on all levels of government.
I agree,
And
but that's our job
do
if
we-
they stop
do we-
doing that.
And that's what I think. We send that message.
Yes.
We have to say,
Yes.
knock it off.
yeah.
Because the legislature has not, the legislature has left it open.
Isn't that a
Well-
workaround? This is a workaround to me to be non-transparent.
Yeah.
That's the way I look at it. Using your personal cell phone, using a personal Facebook or a media and you lock it out, but you're doing business, government business, it's wrong.
And see, we've been doing this and we have yet to have our hands slapped by either
the
the
legislature.
legislature clarifying it or a court case. So it's my intention to continue to do it.
But where does that leave Jordan School District?
Well, it means that,
Obviously, Mr. Robinson, we would like to send a message to him to cease and desist this behavior. But where does that leave Jordan School District?
it means that they,
In the future.
in the future, if this comes up and they ask Mr. or
Anybody.
Robinson or anyone on the board for their personal emails, that person better provide them.
Can I ask Mr. Van Komen a question? So Mr. Van Komen, is that true? Does the school district give board members the option of using the official email or using their own? And Mr. Robinson chose to use his own? Or what's the policy?
Yeah, my understanding is, based on the statute that they will provide and they give them that option. But again, there's nothing by statute that requires an elected official to choose to conduct its communications through the district. That's the position that the district takes. I haven't seen anybody point to anything different. They just simply have to provide an email and a phone number where they can be contacted. That's what's designated as a public record.
And to Linda, that may be true, but that doesn't negate the public's interest
Yeah,
in some of their emails.
yeah. Well, the reality is, grammar was established long before electronic communication. And the legislature has never decided to take it up and tighten that up.
Because it's against their own interest.
But
Well,
Graham-
they're exempt. Yes, they're exempt themselves and they don't have any interest in unexempt.
Well, and
anybody
the
else.
only people they exempted were themselves.
Yeah.
Well, yeah,
And then, do you know what I'm saying? And they have their own policy.
I
for
know,
how they
but
did it.
there's also a.
If they were gonna exempt elected officials everywhere, then maybe they would have done it at the same time, right?
Or maybe not.
But to Nancy's point, they have very strong policy and follow retention schedules.
Yeah.
And I do think grandma does address it actually, because it addresses it in any form. So it's a communication, we're not talking email, we're talking communication here, in my opinion. The different is the form that the communication took place in, and grandma addresses in any form.
Okay.
Right? So I think, you know, what's the information, you know, what is the record? The record is the communication. You know, the email is the form it was taken in, that the communication happened in.
And
My-
so it's the
in my
nature of the communication that determines it, not where it is.
Yes. That's how I,
Yeah, the retention schedule is courts.
Yeah.
And the legislature can stop us at any point. But I think we've been pretty clear.
And to Nova's point, I think in a way it's a contractual agreement. They put his personal email out there on their site. When I'm conducting the people's business, this is how I want you to communicate with me. That seems really clear.
And not only that, he's on his blog or something. He talks about getting all these emails and yet he hasn't kept them. Come on. You know, he might be lying about all the emails he's got.
We don't know.
We don't know because he's not keeping them.
But in the meantime, we can
So-
send a message, but how does that help the petitioner?
Well, it won't,
yeah,
but
I mean, we can send them back to do another search, to have Mr. Dr. Robinson do another search. Will it merit anything?
Well, I think the petitioner has demonstrated. His
That
wife
there
submitted a
are,
request. She receives something different than he did from his initial request. So there's something there.
well, are we ready for a motion?
Delete the things that.
We don't know.
Can I just say, in the message, in the letter from the district, it says that Daryl Robinson deletes his messages. So he does delete them. So,
Why he doesn't.
They don't
Didn't
have-
respond.
On why you have
He
this.
has stuff because he's already deleted it.
yeah,
But our motion has to be such that. I think we have to uphold the appeal. And request that the district coordinate with Mr. Robinson in the future. That he understands that he's under an obligation to keep those emails. Make them available if requested. Is that a?
But are you also suggesting that they go back and do another search?
Yeah, I don't think it'll do any good, but it will to strengthen. I mean, the fact that we're granting the appeal says, to me, says, yeah, it's good. They need to go back and do another search, make sure he's given us everything. And to send him a message that if he's gonna keep his private email, he must keep them. as
Retain
records.
those that attain.
Yeah, what's the word?
Retain those that conduct the public's business.
Yeah,
According to
that's
Jordan
good.
School District retention schedule.
Yeah, good.
See, it's good to have.
It's like that.
Yeah, I think we should cite the legislative intent. Which is 63G 21021A.
So that
And
was,
I think
that
we
was a
should,
friendly amendment to your motion.
yeah.
All of the friendly amendments are accepted.
Did we reference the Allen v. Utah County order?
Oh, sure.
I don't know what the order number is.
And maybe we ought to reference the Salt Lake City School Board,
Yeah.
was it? But we gotta look at it
But yeah,
first.
reference those two that, I know for sure that the Allen versus Utah
Right.
County directly. But I went and read it, but I didn't write down the. I don't think that's-
I might have that too, if you need it.
You have the Salt Lake City School District?
I don't have that one.
We can research and add those in the reasoning. The order is just the decisive
Yes.
action of the.
Yeah.
Right.
I'll include.
Okay.
That was right.
Rebecca.
So the order, so the motion is to grant the appeal, the Jordan School District needs to do another search. An email related to the public business needs to be retained according to district policy and provided under 63G 2201A.
Yeah, but let's say retained in his personal email. We need to,
Yeah, according to the Jordan School District's retention schedule. Not just retained
She
according
said
to their
this.
schedule. I didn't think it did.
You want it to say?
yeah, because
Well, because personal emails, you might,
Careful with that word.
yeah, I'd be careful with that word. I think what it needs to reference is the legislative intent. 63G 21021A, which says that the public has a right of access to information concerning the conduct of the public business. Because we've ruled the personal communications, but we've looked at them to see if they were personal communications or not. Ruled is the right.
We need you to read it back.
Yeah.
Sure that
She's
you're
working on
comfortable with it. No pressure.
what have you done to my motion?
The motion is to grant the appeal. The Jordan School District needs to do another search, and email related to the public business needs to be retained according to district policy and provided under 63G2 102 that the public's right of access to information concerning the conduct of the public's business.
Yes.
Yes. Well done, Marie.
I would second that.
So we have a motion from Marie and a second from Nancy. Any discussion to the motion?
Question, I guess. So let's say we did not. Then to go to. Searches. Don't think that there's. Is granting the appeal just, is that the message we're sending?
Yes.
There is nothing that's going to happen from it other than. Telling Mr. Robinson or the school district. You need to follow these rules. That is the granting of the appeal.
Okay, so all in favor of the motion? Say aye.
Aye.
Any opposed? No one's opposed. Okay, that motion carries unanimously. So the parties, I want you to know that the order will be reviewed and signed by the chair and then distributed by the executive secretary to all the parties within 7 business days. And either party may appeal to district court within 30 days, the date of the order. So thank you for your time.
Thank you.
Saunter for just 2 seconds. 2 minutes.
Well, I say 2 seconds.
Okay.
I think a motion. Minutes.
Motion granted.
So can I just say something off the record to you guys? I think I appreciate you guys understanding the retention policy of the district. When I met with the superintendent, he did not know that they even had a retention policy. So thank you guys for seeing that. And I appreciate what you guys have done. So
Thank you.
I appreciate it. Rebecca, thank you. So.
Yes, I'm here.
Is he here in person?
They're both online.
There was evidence.
Yeah, I think everybody's back. We'll call the meeting back to order. The next item on the agenda is Paul Amon versus the Attorney General's Office. It's hearings 2022-215 and 2022-216. And Mr. Amon is requesting fee waivers for court transcripts and a fee waiver for disciplinary records. Both of you have been before the committee before, so you know how this runs. So Mr. Amon, the time is yours.
Thank you, Mr. Chairman. With regard to the request for transcripts, I submitted a brief, and I actually submitted a brief with regard to both of these matters. And before I get to that, I should thank all of you for being here. It's already been a long morning, and I know you're all volunteers. I appreciate how hard you work. I'm sorry that I can't be there with you in person, but I'm in a different state. But I do appreciate your time. I have a standing objection to you being represented by the respondent to this request, the Utah Attorney General's Office, and this is just Mr. Swan. I'm sure is a fine fellow and a really good attorney. but I need to make that objection in order to preserve it here. Historically, you addressed that very briefly, and I would appreciate if you would do that, Mr. Chairman.
We note your objection and still hold the same position.
Thank you very much. So I submitted a brief with respect to the transcripts, and those transcripts have been obtained. I've obtained those through the AG's office's counsel, which is Ray Quinney Nebaker in this instance. And I believe that Ray Quinney Nebaker has provided the records, and that your records, the State Records Committee's records, should reflect the fact that that request has been completed or has been complied with by virtue of the fact of a third party providing those records. So that, I'm not going to argue that issue today. There is no reason for that. I won't take up any of your time with that. I just believe that your records should reflect that that grandma request has been complied with. And I should note that the Attorney General's office has given transcripts to other requesters in other matters without a fee. So, and in fact, that was Dr. Zimmerman, whom you heard from earlier this morning. So without further ado, I'll address the other matter, which is records of discipline. And I submitted a brief to you with excerpts from the order that Judge Skanke issued in this matter on a grandma request that I did back in February of 2017. Judge Skanke is not a new judge. He's been the presiding judge for the 3rd District Court in Utah, and that's the district with the most cases. So probably you could argue it's the most significant district in the state of Utah. And he's presided over this matter since 2017. Judge Skanke is a highly regarded jurist. He's well familiar with this case, and he made specific findings that the Assistant Attorney General on that matter initially, who was Daniel Widdison, who appeared before this tribunal, made claims to this tribunal that were inaccurate and untrue. And while Mr. Widdison was making those false claims, it was Lonnie Pearson, who's present today for the AG's office, who was sitting right there next to him as part of those proceedings. The AG's office does not hesitate to go to such lengths to prevent me from getting records. We tried that case involving that grandma request before Judge Skanke last year in August and late September. And the AG's office has since filed an interlocutory appeal with the Utah Supreme Court and it did an additional one last year to try to get that case from even going to trial. That effort was unsuccessful. And of course, the case went to trial, but the AG's office took every measure to prevent me from getting records. Ultimately, I received over 13,000 pages of records in spite of the adversarial combat that the AG's office put me through. But Judge Skanke found that they did not do a reasonable search, that the AG's office holds animosity towards me, which borders on hostility, and refuses to provide records that they're still withholding and refusing to provide records. That's in that matter. After Judge Skanke issued that order, the AG's office still didn't comply and stop that adversarial combat. They brought their next interlocutory appeal to the Utah Supreme Court. And as indicated, that matter is still pending. So let's talk about the present request. The present request that I have is for disciplinary records. Those records are explicitly public under grandma. It's section 63G230130, which states that records that would disclose information relating to formal charges or disciplinary actions against a past or present governmental employee are public if the disciplinary action has been completed and all time periods for administrative appeal have expired and the charges on which the disciplinary action was based were sustained. You heard earlier today, you heard Assistant Attorney General Blaine Thomas say that if the charges were brought and sustained, then the public has a right to know. That's my argument to you today about these records. That's what I'm asking for. Mr. Thomas also said these words, I wrote them down because they're important. He said, if conduct is serious enough to warrant discipline, then that information should be made public. That's what I'm asking for. Public records of completed, sustained public discipline of public employees. Mr. Thomas made the arguments that these public records should be provided. The public interest aligns with providing these records under grandma. The AG's office cites you to the Jordan River case, arguing that it says you don't have to do any weighing. All you have to do is just deny my request because they can demand fees without it even considering any weighing analysis. The AG's office desperately wants you to avoid considering the competing interests because the AG's office has no legitimate interest in hiding records of discipline. The public has a right to know about discipline of attorneys working for the public whose salaries are paid with public resources and are hired to represent the public. As discussed in the Jordan River Restoration Network case, the issue with regard to a governmental entity seeking a fee for responding is the fee the governmental entity is seeking reasonable? The AG's office gives you no basis to find that it is reasonable. Lonnie Pearson never even claimed to have asked Etta Atkins, who's the head of human resources, for records of discipline. She would likely know off the top of her head who had received serious discipline and be able to point to the records within 5 minutes, not a half an hour or 5 or 6 hours, but within a relatively short time. And Judge Skanke also noted in the trial that we had this past year, the following, and I quote, "The records custodian inexplicitly did not ask either of two people for any documents subject to this inquiry, although some emails produced reflected communication between the parties that support this very claim. Not designated either of these two principles as record custodians is unreasonable." So you've got an AG's office that holds hostility towards me. You've got Mr. Pearson refusing to ask primary record holders for records. The searches that the AG's office makes are not reasonable. Then you also have historical problems with the AG's office not being able to find records or keep records appropriately. In 2015, there was a legislative audit performed by the legislative auditors. They issued a report, 2015-05, that said that the AG's office had to improve its records management system. It gave the AG's office $800,000. This is back in 2015, 8 years ago, and another $300,000 for the personnel to help with the record management system. So that's over $1 million. The legislature said, if you need more money, let us know. We're willing to give you those resources. Just let them know. Let us know. So they received a one-time fee. I don't know what else they may have received since then, but they do receive an ongoing amount of $300,000 simply for records keeping. And the problem that the AG's office has with records keeping has still not been resolved. Judge Skanke analogized it to asking a person who has been blindfolded to look around his courtroom to find a penny. And it's just not reasonable. So the AG's office is asking in this instance that you pass on the cost that it purports to have without giving any support for that. It asks that you pass on the cost of looking for records with its inept systems to the requester. That's not appropriate. That's simply uncalled for. They're public records that I'm asking for. There was a request earlier today for records of discipline that may or may not have been fully completed. In this instance, I'm asking for records that have been completed, discipline that's finished, investigations that are completed, and information that should be available. The AG's office could have started with saying, we'll give you what we've given other requesters, but instead they say, no, we're not going to give you anything. So that's not exclusive to the AG's animosity and stalling is not stonewalling is not exclusive to that other case. The AG's office's animosity doesn't decrease because I've asked them for more compliance with grandma. It only increases. In the past, they've provided records of discipline without cost. Now they're using this excuse of how much it would cost to keep me from getting records. The reason that Mr. Pearson would have to ask someone other than HR for records in order to get records of discipline is because the poor records keeping that they have. So ask yourself if there's some sort of unwritten policy at your organization that would fly that says if the person who's the head of organization doesn't have the records, then we don't have to provide them, whether or not that's appropriate. Because records of discipline exist in this office. The records of discipline have been publicly reported by KSL in one instance with respect to Gary Bell. They have those records. The AG's office could provide those records to me simply by forwarding whatever email they sent to KSL, but they're unwilling to do that. I'm asking you to order the AG's office to provide records of discipline instead of simply refusing and seeking to block the request by asking for money. Etta Atkins, the head of AG Human Resources, could take half an hour and copy discipline files that she's aware of to Mr. Pearson, and he could provide those to me. That shouldn't take hours upon hours of searching. It should be something that she's able to do within a relatively short time. And whatever other records they may be able to obtain by doing a reasonable search throughout the office, because that has to be done in such a difficult way and is so laborious, the cost of that should not be passed on to the requester. The AG's office should bear the cost of that. That's what I'm asking you to do. Find that the request that the AG's office is making for fees to be unreasonable and to provide this information because it's public information, it's public records, and the AG's office has historically been stonewalling my requests, not providing evidence of public records for years. There are requests that I made back in 2014 that I've still been only recently requesting that I've only been receiving records from the AG's office because they've kept those records hidden for so long. This is not an unreasonable request, and I ask you to issue the order. Thank you for your time.
Thank you. Any questions for the petitioner? Hearing none, we'll go to Mr. Pearson.
Thank you, Mr. Chair and members of the committee. I also appreciate your time here. And I'm going to focus on the issue which is actually before the committee, and that's the issue of whether the fee waiver denial by the office in this instance was unreasonable. Much of the background that Mr. Amon provided really has no relevance to that question. And so that's what I want to focus on. His request asked for records of disciplinary action against any AGO employee since January of 2014, so a period of more than 8 years. He did identify a few individuals specifically, but he didn't limit his request to those individuals. The office denied his fee waiver request based primarily on his failure to show that the request primarily benefits the public, and that is the standard under GRAMA. It's not, are the records of interest to the public? It's, does the request primarily benefit the public? The office decided that his request did not primarily benefit the public. It really is intended to continue his ongoing litigation efforts against the office. Mr. Amon wants to compare himself to KSL or other media requesters that have asked for similar records. The only difference is that they're requesting the records for publication in a news story or for, but Mr. Amon clearly has a different purpose in mind for these records, and that is relevant to this analysis. The office also considered other factors that are absolutely relevant to a fee waiver determination. That included the large numbers of requests that Mr. Amon has filed and the numerous fee waivers that he has received in the past, and also the broad scope of this request and the impact that fulfilling it would have on the office fulfilling its other responsibilities. And those are absolutely relevant and appropriate factors for the office to consider. In his CAO appeal, or Chief Administrative Officer appeal, Mr. Amon didn't even challenge the determination that he failed to show that his request primarily benefits the public. His only focus was he rejected the 20 to 30 hour estimate for gathering the records, which I will address further. We invited Mr. Amon to clarify his request and whether he wanted to limit it to those individuals that he specifically identified, and he's never done so. So still we're faced with this very broad request for all disciplinary records, the entire office for 8 years. Mr. Amon wants to assert that, the head of HR can just go and grab these from a file in half an hour. I don't know what he bases that on. Now on the flip side, he says, well, actually it would take a lot of research because our records keeping system wouldn't allow that. So I don't know which one he's going with, but the fact of the matter is that those records cannot be gathered in a half an hour. And we did in fact go to the head of HR and ask how long, for an estimate of time that it would take to gather all of those records. And that is what the 20 to 30 hour estimate is based on. Going back to the analysis here, petitioner can't show that his request primarily benefits the public rather than himself. Again, he's not a media representative. He's requesting the records solely for his own use in his ongoing litigation against the office. And if all Mr. Amon wants is records that have been provided to other disciplinary records that have been provided to other media outlets, we're more than happy to provide those records without cost. But that is not what he has requested here. In fact, that the office has produced records free of charge to the media refutes Mr. Amon's point. When it isn't truly primarily in the public interest, the office does waive the fees and provide records free of charge, but that's not the case here. But the important part is that even if petitioner could show that his request primarily benefits the public rather than himself, even if he could make that showing, the office is still entitled to deny a fee waiver based on consideration of appropriate factors, that is, as it's done here. Because GRAMA encourages fee waivers under certain circumstances, such as when the request primarily benefits the public, but it does not require that. So the Supreme Court has held that when reviewing a governmental entity's denial of a fee waiver request, the question is not whether the government entity abused its discretion, but whether its denial was reasonable. And so that's a very low threshold for the government entity to meet. Reasonable just means that it was based on relevant, appropriate considerations and that it wasn't arbitrary and capricious. And here the office has specifically explained the reasons for its denial, and those are appropriate. The numerous requests that Mr. Amon has filed, that he's received fee waivers for in the past, the burden that this broad request would place on the office, and its impact on the office's other responsibilities. As I said, the HR director estimates 20 to 30 hours to go cull through all of these files and provide those records. That is a significant burden on our HR department, which is relatively small. And so that's a relevant factor. So petitioner has not shown that the factors considered here were inappropriate or irrelevant. And therefore, he hasn't shown that the denial of the fee waiver request was unreasonable. Mr. Amon also complains about the office's fee waiver policy. I will just point out, all the fee waiver policy of the office does is codifies what is already in GRAMA and case law. That a person requesting a fee waiver has the initial burden of showing, if they're requesting under the provision for public interest, they have the burden of showing that it truly primarily benefits the public. And then it lists some of the other considerations that the office deems relevant to its analysis. And so rather than being arbitrary or capricious, this policy is intended to do just the opposite, to make sure that the decision maker is considering relevant and appropriate considerations. So the policy that the office has is to benefit the public and is in no way improper. Again, I will just reiterate the Jordan River restoration case by the Supreme Court. They clearly stated that although allowing governmental entities to impose fees is one way that GRAMA balances the government's interest and the public's right of access, GRAMA does not require for fee waivers the same balancing analysis that applies in the context of records requests. So Mr. Amon wants you to focus on the balancing test that's used for whether a record that's classified as non-public should nevertheless be released to the public. That weighing analysis has no bearing on the fee waiver decision here. Instead, and again quoting Jordan River, upon judicial review of a government entity's fee waiver denial, the ultimate question is not whether the entity abused its discretion, but whether its decision was reasonable. So quote, GRAMA does not require the same substantive weighing analysis either from a government entity or the reviewing court, or in this case, the records committee, in determining whether to grant or deny a fee waiver. So the fact that the office did not go into the balancing analysis that Mr. Amon wanted is of no moment. It doesn't matter. It's not required of a government entity. It's not required of you. So in summary, the office properly denied Mr. Amon's request for a fee waiver in this instance based on consideration of appropriate factors. And I would urge the committee to uphold that determination. Thank you.
Thank you. Any questions for the respondent?
Mr. Pearson? I'm just trying to assess how many hours it should take to do it. So, I don't know what UTAG is. I see that in the request. Can you talk, what is UTAG?
I believe that's Mr. Amon's abbreviation for Utah Attorney General's office.
Oh, okay. And then, I mean, so how many employees are employed that HR would have to? Are they gonna have to?
I believe we currently have over 500 employees. And again, this goes back over a period of 8 years. So you could be talking about double or more of that. I don't know, but it's not a small number by any means. And 20 to 30 hours. I mean, if you divide that out per year, you know, it's basically an hour a year to review 500 plus employees' files. So.
And then is that just a, like, I mean, his argument is that she should know off the top of her head, like, is there some sort of database that keeps track of the people who had discipline actions and what the result was?
No, I'm not aware of any database to that effect. I think there are some reports that are kept that might help direct them to the correct files. But these files aren't kept in a file that says, you know, all AG's office disciplinary records, which is kind of what Mr. Amon's suggesting. They would be kept in each individual employee's employment file as required by our retention schedules. So they would have to, I mean, once they could identify which ones they believe were relevant, then they would have to go to the files and pull them and review whether, and that's another point, is that the only disciplinary records that are public under GRAMA are the ones that have been completed. All formal appeal has been completed. And so that's another issue also that will require some analysis.
We'll go back to Mr. Amon.
Thank you. I don't believe that the question was answered about how many people work with Etta Atkins, and I don't, because I haven't been working for the office for a number of years, I'm not certain what that number is, but I know it's more than just her. I believe it might be 2 or 3 people. Perhaps you could ask Mr. Pearson that question more directly during his next session. But in any event, there's a representative of the GRAMA, there's a GRAMA committee throughout the AG's office, and there's a representative on the GRAMA committee from each division who could be tasked with coming up with these records. But Mr. Pearson rightly talks about what's reasonable and what isn't reasonable. And he said to you, and I wrote this down, he said that the AG's office would be more than happy to provide those records which have been provided to other requesters without cost. So the question is, why hasn't that happened? Is it reasonable that that hasn't happened? I suggest to you that it's not reasonable that that has happened. The proof's in the pudding. If the AG's office would be more than happy to provide those, why hasn't it done so? And if those records have been published somehow, then it's the responsibility of the AG's office to tell me where I can find those under 63G2201 subparagraph 8. Which says exactly that. If those records are publicly accessible online, then it's the obligation of the governmental entity to tell the requester where to find those. So there's no question that there's completed discipline of AG employees. Gary Bell's a prime example. He now has criminal charges pending against him for child sexual exploitation and also for sex crimes against his own grandchildren. And a couple of years before he had charges brought against him, he was disciplined by the AG's office. Those are records of discipline that should not be hard to find. I've given them the name, and that should not take any time whatsoever to find those records. I've also mentioned specifically Stephen A. Withridge, and I talked about him in the brief, someone who did something deplorable and should have been disciplined for that. It may be that he wasn't, and that's an important question. Was he never disciplined? But if he was, that's a public record. And what distinguishes KSL from myself is KSL has a lot of power and a lot of money, but KSL is no more or less a member of the public than I am. And if the AG's office's suggestion is that whatever records they provide to me through grandma, I need to publish in order to have a legitimate request for them, then I think Mr. Pearson may be speaking at odds with the rest of the office. I think the last thing the Attorney General's office wants me to do is provide to the public in a public forum the disciplinary records that I've already received. There's no question, and Mr. Pearson certainly can't question the fact that my position has been throughout and for years that I'm a whistleblower. I'm exposing or trying to expose corruption in the Attorney General's office. I do have a pending federal case that matter's been pending for many years. I also have a case in state court, a grandma case that continues to be pending because I continue to seek records that the court has said the AG's office does not keep reasonably, and that therefore there's no way that they could do a reasonable search. There hasn't been a reasonable search in this case because the AG's office doesn't have the ability to do one. And instead they want to pass the cost of that search on to me. And when I say that records could be found in relatively short order by Etta Adkins, I'm talking about cases, the names of which I have provided. Let's start there. Give me whatever disciplinary records there are on the completed investigations with regard to Stephen Withridge, Gary Bell, Cindy Polson, and Craig Barlow. I have narrowed my search. I've told them what I asked for. I narrowed the search in the request by listing these people specifically. And there has been in the AG's office a huge issue of spoliation, of the AG's office not properly keeping records. Spoliation was mentioned earlier in a different matter that you heard today, and that's a matter that's currently pending before the federal court as well. I have a motion pending against the AG's office because it doesn't preserve records even when it's told and knows and has the legal sophistication to be aware that it must take the proper steps to preserve records. So I ask you that you order the AG's office to provide the records that I've requested. That's what grandma contemplates. That's what grandma mandates. Thank you.
Have a question?
Yes.
Is it Amon or Amen?
It's Eamon. Thank you for asking.
Apologize, because I know we've seen you before, I keep forgetting, and I apologize that doesn't stick in my head. Mr. Amen, are you willing to limit your request to those individuals? Because when I read the request that we're here on, it says any and all. Any and all, including but not limited to. So I don't know if I'm hearing you say you're willing to limit to those few people, because they have to respond to the request in whole.
I understand, but part of my point has been that while they have to respond to the request in whole, normally what Mr. Pearson has done in the past is say, we don't have all the records that you're looking for, but here are some. And my point about there being more animosity and less desire to comply with my requests, as indicated by Judge Skanke, is that they're not even giving me what should be readily available because they have already provided it to another governmental entity. So I've given, or I'm sorry, another public records requester like KSL. So I don't know that it would be appropriate for me to say I'm willing to limit that to exclusively what I have the people that I have named, but I'm willing to say, yes, that's a starting point. Let's start there. And then once you've provided those records, let's have information from Etta Atkins or whomever to say, this is why it would be difficult to provide these records. You don't have anything from Etta Atkins. You have Lonnie Pearson saying this is what Etta Atkins would say. But as I've indicated before, you've been given inaccurate and untrue information from representatives of the Attorney General's office. I don't know who all has been disciplined, so it's impossible for me to say, yes, it's enough for me to agree to this. Part of the issue is like with Kevin Pepper, his discipline was reported in the media. When I asked for his disciplinary records, they were provided. That's how it should work. There wasn't a charge associated with that. And that's what I'm asking for. If people have been disciplined, it's not always something that may be that the public knows about, but it may be issues where it's someone like Pepper who has broken the law and has been disciplined for it, and we don't know about that. Those are probably the records in those cases may be more important than the ones that KSL or the Salt Lake Tribune are able to find that records out about, because there may be a greater desire on the part of the AG's office to protect those employees for whatever reason, because it benefits the Attorney General's office and or an employee who has been disciplined.
Thank you.
Thank you. Any other questions?
I just had a quick one.
Yeah, go ahead.
Mr. Pearson, you had mentioned, I believe, that if any of the records had been provided to the media outlets, that Mr. Amen, those could be provided to him free of charge. Are any of those names that are on his records request, any of those were provided to any of the media outlets?
So yeah, to clarify, we routinely get requests from people saying, I would like all the records that were released to KSL pursuant to their grammar request. And that's very simple for us to fulfill, right? We just go to the grammar request response and send those same records over. And we're more than happy to do that without any charge. Yes, I believe the Bell one was one, is that the correct name? Was one that we've filled recently, and there may be others that we've filled for the media. So if Mr. Amen wants to submit a request just asking for any records released to the media regarding disciplinary records, we're more than happy to fulfill that. But that is not at all what he's requested here. And I think the question that was asked was a great question. And you notice Mr. Amen's answer was an absolute no. He will not limit this request to those individuals specifically. He wants it to remain the entire office, all disciplinary for over 8 years. Grammar requires that you specify the records with reasonable, you identify the records sought with reasonable specificity. He's not done so. This is kind of Mr. Amen's MO, is to have kind of shifting goalposts, if you will. To not really pin down exactly what he wants, and then to come back with follow-up requests about, what about this? What about that? What about all these other things? And then we wind up in litigation. So rather than do that, before we proceed to process his request, we would like to know specifically what he's seeking, and we can determine what the costs of fulfilling that would be. And again, if he's willing to limit the request to those individuals specifically identified, we can give him a fee estimate for those individuals, and I'm sure it'll be far less than the total for the 8 years. Again, Mr. Amen admits this is really about his litigation. He's requesting these records for his ongoing whistleblower case, as he said, that's pending in federal court, as well as the Grandma case, if necessary, that's now before the Supreme Court. We can't reinterpret a request for someone and say, well, we're just interpreting your request as these individuals, when it clearly says, it's for a certain time period. Otherwise, we'll just wind up right back here, with claims that we didn't fulfill the request. So again, I would urge the committee to find that the fee waiver denial here was entirely reasonable based on consideration of appropriate factors, including the numerous requests that Mr. Amen has filed submitted to the office and the fee waivers that he's received, the broad scope of the request and the time required to fulfill it. That the estimate of time is by no means, unreasonable, unjustified, given the scope of this request. Thank you.
Thank you. So, Mr. Pearson, you were responding to a question. Do you need any more time to?
No, that's fine. I wasn't sure. I just finished up. So there you go.
Great, thank you very much. Okay, so committee, we will now move to deliberation. And I just wanted to clarify, it's my understanding that it's the 2022-215 has been withdrawn.
Sounds like it, yeah. Because it's been compliant.
Because it's been complied with. Is that correct, Mr. Amon?
That is correct, Chairman Williams, yes.
Great, thank you.
Do we need a motion to dismiss it or
Yeah, that's,
no?
no, it's just withdrawn. Okay,
Okay,
great, thank you.
sounds good. Thank you.
Anyone like to begin?
Well, I asked the questions about how many employees and because I wanted to get a feel for whether the time frame being charged was a reasonable time frame. And given that it's 8 years of that time frame, I can see that that's going to take them time to do. So that's why I asked that question. I do feel like Attorney General's office did look at the request and make a determination. They just didn't arbitrarily say, we're not gonna honor the free waiver. They did look at whether it was in the public interest, the numerous requests that they've received, the burden and the impact to the department to pull those files. So I think they did a good job of assessing whether a fee waiver was warranted in this case. Their argument is, I'm convinced that from their argument that they did look at those things.
I was just gonna kind of piggyback on what Nancy is saying. I believe this is a voluminous request because it hasn't been narrowed down to the specific, just those specific folks that have been identified in the records request. So when it goes to any and all, like you said, if there's over 500 personnel in an office, that's a lot of in the records, but that's a lot of research that you would have to go through and analysis.
Well, and every disciplinary action comes to be whether it was sustained or not,
right.
and a determination made of whether that record's public or not. And I, we get this sometimes when I'm dealing with records requests, like we don't try to reinterpret. We might ask them to narrow their scope, but if they're not willing, we have to go with what they asked for and not try and interpret what that means at the point that they're not willing to reduce their scope. Right. And so, I think that's important to know too.
Any other comments or a motion?
I have a new mantra. Information costs.
It does.
It does.
Records management comes at a cost.
There is a cost to government to provide records. There really is. The cost of the research and producing the record. And that is, in my opinion, other residents are paying for that time spent doing that. If the fees are consistently waived. So if there's no further discussion, I make a motion. I make a motion to deny the appeal for 2022-216 because I'm trying to find the exact code. It says that a governmental entity may fulfill a record without charge. So that's but that they aren't required to, which is 203.
Do it according to 203.
Yeah, thank you. That helps because then I was gonna go back to another section. So they are allowed, they may charge a fee according to 203. And the Attorney General's office did assess the reasonableness of the fee. And they are allowed to ask for that in advance if it's over $50 according to the fee.
Why not order him to provide the records that he said he would provide without cost?
Because that wasn't your request.
No. I would suggest going there.
That's my motion.
Okay, so we have a motion from Nancy. Rebecca, will you read that back?
The motion is to deny appeal 2022-216. The governmental entity is not required, or may charge a fee. The governmental entity may charge a fee under 203. And the respondent did assess the reasonableness of the fee. And they are allowed to ask for that in advance if it's over $50.
And could we also cite the Salt Lake City Jordan River case that allows them to charge fees? Thank you.
We have a motion. Is there a second? Second. From Mark. Any further discussion to the motion? Hearing none, all in favor, say aye.
Aye.
Any opposed? So the motion carries unanimously. We'd like to thank the parties for being here. The order
Thanks so
will be
much for your
reviewed and
time.
signed.
Thank you, Mr. Freeman.
The order will be reviewed and signed by the chair and then distributed by the executive secretary to all the parties within 7 business days. Either party may appeal to district court within 30 days of the date on the order. But thank you for your time.
Thank you for your time.
So committee, what parties are here for the next hearing? Are you okay if we? Are we good?
Yeah.
Okay. Mr. Cooperstein, if you want to
If I
come on.
turn pale, just hand me a cookie.
Okay, so the next item is Mr. Ian Cooperstein versus the University of Utah. It's hearing 2022-225, and Mr. Cooperstein is requesting access to records concerning a job.
And also a fee waiver or whatever.
And you'll speak to that. Yes. Okay, thank you. You've both been before the committee before, so we start with the petitioner.
Oh, I'm on the wrong side.
You're fine.
Oh, okay. Okay.
Just threw me off there.
I didn't realize the tables had a designation.
University, if I ever petitions you. We'll be making some history. So you've been here before, so we'll start with the petitioner. You have 20 minutes. And then we'll go to the respondent. There's time for questions and then 5 minutes to summary. So Mr. Cooperstein, please.
All right, great. Well, I'd like to start this hearing by expressing my continued disappointment and the unprofessionalism from the university's Office of General Counsel for once again submitting their position statement for this hearing late. I raised this issue during my last State Records Committee hearing with the university when the committee accepted their position statement that was submitted only 2 business days before the hearing. This time it's 4 business days before the hearing. But it's really hard to take seriously any notion of this committee being unbiased when this kind of favoritism is like on public display. You know, just to point out with the hearing earlier, I had a hearing in a similar matter where I was attempting to retrieve government records that were someone was using a personal device, and I was rejected. There was no request for another search to be done, and there certainly was no directive by the State Records Committee to the State Labor Commission at that time to inform that employee to stop using personal emails and personal devices for government communication. So I'm just kind of curious where that energy was when I brought the same issue to the State Records Committee that was brought with the Jordan School District earlier today. I would next like to briefly address the portion of the university's position statement that expresses displeasure in the amount of records requests that I've made. I'd like to apologize to the university's general counsel, who, while members of the State Records Committee were in camera during our hearing last May, expressed considerable displeasure with the university's administrative services department. I wholeheartedly agree with Ms. Bradway's displeasure in the university's HR department and blame the volume of my requests noted in each of Ms. Bradway's state position statements on what has become the necessity for me to dig through the administrative services department's unethical and possibly illegal misconduct. I'm not making these requests and showing up to these hearings because I want to. I'm doing it because the university's administrative services fabricated documents in my employment. Which brings me to the issue today, which is I am seeking materials for a job posting. It's very simple. I brought university policies here. They outline how jobs are supposed to be posted, whether they're internal or external. The university's position statement tries to conflate all this stuff and confuse about internal postings, external postings. So I just brought the policies that clearly outline that every job created at the university has to be posted at some point, whether it's for 3 days, whether it's for 7 days. That remains to be seen based on how the job is classified. The particular job that I held is outlined in example number 3, which clearly mentions that my job is around 30 hours a week. Meaning that it was supposed to be posted for several days publicly because it exceeds 20 hours a week, and also needed to be a public posting because it existed for over about 4 years, which is much longer than the 9-month period stipulated under what a temporary job would be. So the job posting that I am seeking the materials for meets all the requirements to have been posted by the university when it was created in 2015. I've already been here once before trying to seek materials that were fabricated unethically by Diane Coons, the university's HR director. This is no different, and interestingly enough, that is who the university put in charge of responding to this request. So essentially, I asked for these posting materials, job posting materials, and the university told me that none existed. Now, I made this same request internally 2 years ago, and Ms. Coons, the same person that said that there were no records for this job posting, provided to me this document. So she's already responded to this request once before and provided materials, though it wasn't through GRAMA. When she provided me this document, the metadata on the document showed it wasn't created in 2015 as the job posting was, but it was created after the fact, after I was terminated from the university, meaning that this is likely a fabrication. Now, I've come here to ask the university very simply to provide job posting materials for a job that under their own policies and under the law needed to be publicly posted or internally posted at some point. They provided no materials whatsoever responsive to the request, but we're happy to try to charge me $50 for the search that they went through. before leading up to this hearing, I said that I would be willing to accept an affidavit with a legitimate reason why these job posting materials would not exist as is required under university policy. The affidavit that I received was written by Ms. Coons, and really didn't fulfill at all the request that I had, which was, I just wanted a reasonable explanation why these materials would not exist, because under university policy, they have to somewhere, unless the university is in violation of those policies. As it comes to the fees that I was charged, I was curious to see how much work the university actually undertook for these searches. So I contacted the HR 3 different times, and I received 3 completely free searches to fulfill this request. One time I even went to the HR office downtown. The searches took less than 2 minutes apart. Now, in the university's affidavit, which I rejected, Ms. Coons outlines that she did not even perform the search for the documents. She tasked 2 different employees, 1 HR analyst and 1 internal campus recreation employee. So let's say it took them a little bit longer. There may have been 10 minutes of searching between both employees for both searches, and that's being incredibly generous. I've received dozens of requests back from the university that, were fruitless and provided no documents whatsoever. I've been charged 0 times for those fruitless searches, which I assume, based on this, if I'm being charged $50 for less than 10 minutes of work, where no work product was generated, then does that mean that in all the requests that came up blank before, were they even searched at all? Because I wasn't charged anything, and I assumed that those searches were pretty thorough, which who knows at this point. But I'm here basically to dispute the fact that I'm being horribly overcharged for this search to have even been conducted. It's a very basic HR search. There were like 4 or 5 keywords that needed to be searched. It's a rudimentary thing that basically a college student analyst could do. It's not a deep search through disciplinary records and OEO files. It's literally just searching for a job posting in 2 different departments. And if the university can't provide to me at least what they told me was a legitimate document from that job posting 2 years ago, then I would like an explanation, not just the university saying that the records don't exist, but an explanation as to why they would not exist when university policy clearly indicates that jobs have to be posted somewhere, meaning that records were generated and those records are somewhere. So, yeah, I would like that would satisfy me, even if I didn't receive records today, is a reasonable explanation as to why these records don't exist when they supposedly existed 2 years ago. And I would like to dispute the fact that, I'm being charged $50 essentially for something that provided nothing, where in the past, when I've gotten documents back, I've been charged exorbitant fees. I've been charged $1 a page sometimes, but at least they generated records. I've never, ever, ever had a records request come back empty. That was such a simple request and been charged so much money. I think it's abusive. And that pretty much concludes what I have for you guys.
Questions for Mr. Cooper?
So if I understand everything that I read, so you took a position with the university as the job posting you're looking for.
So here's what happened. I was offered a promotion. I was told to submit a cover letter. It was never through a portal or anything. I was told I received the promotion. What I learned recently is that though I received the promotion and I was working 29 hours a week, the university recorded the amount of hours I was working as 4 hours a week. Even though my position was permanent, it was recorded as temporary. So essentially, something went wrong in the hiring process where where policies were not adhered to. So I held this position, I applied for it via cover letter, but I've never actually seen job posting materials until Ms. Coons fabricated this in 2019.
So attachment 10 that you have supplied, that shows the screenshot of the position was temporary and full-time from 2008.
Yeah, that's a screen.
Not the job posting you're looking for.
That's
because
not the
that-
job posting, that's the HR code that shows that Ms. Coons, the woman responsible for this record search, also listed my job incorrectly in the HR system.
As technical assistant.
Yeah, and then listed as 4 hours a week when I was working 30 and listed as a temporary worker when I'd been there for 11 years. It was, basically employment fraud to deny me benefits.
Thank you.
Thank you.
Oh, I get that.
Go ahead.
You keep holding this piece of paper up. That could be any piece of paper.
Well, I passed it over here for
One,
the committee to,
so,
I believe it was in the documents that I submitted to.
oh, so which one?
I don't actually have that list with me.
Okay.
It says personal trainer supervisor expectations.
Oh, okay. And that's the position that you were promoted to.
That's the position I was promoted to, yes. And these are the sheets that are supposed to accompany job postings. So they're like ones that look identical to this, where when you log onto the portal to apply for a job, there are several different forms, and one of these, this is one of the forms that is generally received by an applicant. Or viewed by an applicant, I shouldn't say received.
Okay, we'll go to the respondent.
Hey, hi, thank you. I'm Rebecca Bradway, Associate General Counsel with the University of Utah.
Introduce yourself. I'm Austin. I'm also a member of the Office of General Counsel of the University of Utah.
we need you to talk a little louder, I'm sorry.
My name is Austin Wienig. I'm the research attorney at the University of Utah.
Okay. All right, thanks so much for taking the time to meet with us today. So I guess I don't know that I need to address everything that was just stated, but I do think that there were a number of sort of statements and assumptions based on some false information. So I just want to kind of start there. As you can see, this request is specifically for some job posting materials. I think that that's been made clear, but there's really just two issues I want to address here. So I'm happy to sort of walk through how the university searched for responsive records and why we were unable to locate any, and as well as our reasonable fee that for responding to the request. So with respect to the no records, so when we received this request, Human Resources performed a search of all of their database. They pulled actually, so you can see in the request, excuse me, this talks about Campus Recreation Services creating this new position. And it talks about that this was done in August 2015 and the position existed from August to July 2019. So actually what HR did is they went in and they pulled every single job posting that was advertised by Campus Recreation Services during that time frame, during the August 2015 through July 2019. And they actually looked at every single job posting advertised by Campus Rec. None of those job postings had the titles listed in the request, this personal training supervisor or personal training lead or any similar title. Their files show that Mr. Cooperstein was hired into this job code for technical assistant. And for his entire time at the university, his job history doesn't show any change in that job code for his entire employment. We also had Campus Recreation Services also performed a search of their files to see if they could actually locate anything, since this would have been advertised under them. They also did not locate any records in their search. As we mentioned in our initial response and in response to the internal appeal and in our written statement, and I'll just reiterate, based on discussions between HR and Campus Rec, it does appear that Mr. Cooperstein may have received some sort of internal promotion or working job title change during this employment. But this does not necessitate a separate job posting that would be part of the HR system. And that would result in a change to his job code or his formal job title. So this is why we were unable to locate any records. There was simply no job posting that HR had, no job posting materials that Campus Rec could find. So we did do a thorough search, but because there was never any job posting for this, because it wasn't necessitated, that's why we were unable to locate any records. The fee that we charge was reasonable fee. As you know, GRAMA permits government entities to charge fees for certain things. It also just has very explicit prohibitions for when you cannot charge certain fees. And GRAMA does permit a government entity to charge for search time, retrieval, and other direct administrative costs for complying with a request. It's true that typically when we do receive a GRAMA request seeking a job posting, we can find that quite quickly. And we can provide that to the requester fairly promptly at little to no cost at all. And we would have been happy to do so, here, as we've done in many other situations, had we been able to locate a job posting. In this circumstance, however, because we were unable to find anything and we continued our searches, we were required to expend additional resources above and beyond what would normally be required to search for a job posting that existed. So we did provide Mr. Cooperstein with a sheet that sort of lays out all of the costs associated with the request, the number of individuals who did the request. That was 2 people in HR, 1 person in Campus Rec. Talks about the fees, the amount of time they spent, and it also notes that we waive some of those fees, even though there's no legal obligation to do that in these circumstances. Excuse me. So the legislature has very clearly provided that a governmental entity may charge fees in responding to a records request. And like I mentioned, there are just very limited prohibitions that are explicitly spelled out in GRAMA for 3 reasons. And I did want to bring, excuse me, let me just grab this. But I did want to bring specific attention to one of these provisions for charging fees that you may be familiar with, that the legislature just amended last year, that I think speaks to this issue. So previously, and it still says this in GRAMA, that a governmental entity may not charge a fee for, it says reviewing a record, inspecting a record, and then the first quarter hour of staff time spent in responding to a request. Now, the legislature last year actually created an exception to that 3rd prohibition on charging fees. And it now states that notwithstanding that, a governmental entity actually may charge fees for the first 15 minutes of staff time in just responding to a request. If 2 criteria are met. First, the requester is not a media representative. And second, the requester previously submitted a separate request within the 10-day period immediately before the date of the request to which the governmental entity is responding. So the reason why I think this is important is because I think it really speaks to, in making this change, the legislature recognized that requesters that have a pattern of making numerous requests one after another within this 10-day period, should actually bear more of the cost of the resources that governmental entities are using in just to respond to these requests. So I think this change specifically supports the legislature's intent that requesters should not be allowed to unilaterally cause the expenditure of significant government resources in responding to multiple requests doing these long thorough searches with absolutely no obligation for the requester to pay. In turn, I think this also supports the fees we charge for this request, which were reasonable to have multiple people check to make sure we were doing a thorough search based on the information provided by the petitioner. I do want to note that when there is a dispute in fees, we do try to work with requesters through mediation or otherwise, to not sort of take the committee's time. We always want to consider and consider how we can work with these fees. And in many times we do agree to waive or reduce fees. And, you know, the petitioner has also mentioned that we have not charged fees in other circumstances, which I don't think necessarily results in the fact that we would never be able to charge fees. I think that this is continually supported by the legislature's intent here, where they made this change to explicitly say, if someone is making repeated requests, the governmental entity is having to spend, you know, resources time and time again for these requests one after another, then we have explicit authority under the statute to do so. And again, in this case, we did waive part of those initial search fees, but the remaining fees that we charge, we think are reasonable based on the statute. In closing, I guess, you know, GRAMA does provide specific appeal rights. I don't think those specific appeal rights actually apply here. Having no responsive records is not an access denial subject to GRAMA. We didn't deny access to any records. We simply could not locate any records. We don't have a job posting that looks like this. And also charging for reasonable costs as permitted by GRAMA also does not amount to a denial for which the statute provides an appeal right. As we noted in our written statement, here we have, you know, in this specific request in these appeals, we have a requester on the one hand who's demanding that the university continue searching in all these different places for records. But on the other hand, claiming that he should not be responsible for any of these fees, any of these costs related to these efforts. So we don't think that this is a reasonable interpretation of GRAMA. We don't think that it supports this sort of context here. So we would urge the committee to deny this appeal for those reasons. And I'm happy to answer any questions.
Question?
So going back to the code, 63G2203, I'd like to direct you to 1A and 2A. Subject to section 5, a governmental entity may charge a reasonable fee to cover the governmental entity's actual cost of providing a record. And 2, when a governmental entity compiles a record in a form other than that normally maintained, the actual costs under this section may include the following, which is where you've taken the cost of staff time for search, retrieval, and other direct administrative costs. I read that to say that those fees apply when a record is provided or compiled. Could you speak to that?
Yeah, sure. I'm happy to speak to that. So you're right that it talks about charging a reasonable fee there. And then this subsection 2A is kind of interesting because 2A does start with that piece there, but then we have the cost of staff time for search, retrieval, and other administrative costs for complying with the request. I think that it is the legislative intent to permit government entities to charge for these things. This is, I would read this to be sort of, it says that when a governmental entity does this, they may include charges for the following things. I don't think that that restricts what a governmental entity can charge, but it does give direction for the fact that we can charge for staff time for certain things. We can charge for search, retrieval, and other direct administrative costs. And then this piece about computer output, the only restrictions in this section are really in subsection 5, which says we cannot charge a fee for reviewing a record, which we haven't done here. We can't charge a fee for inspecting a record, and we can't charge a fee for this first quarter hour of staff time, except under those circumstances I mentioned to you. And it is interesting because you do see this charges under 2AI that talks about to comply with the request. Under 2B, you see that the hourly charge talks about the necessary skill and training to perform the request. And then 5C doesn't speak at all to actually providing any type of record. 5C specifically says that a governmental entity is not prevented from charging a fee for the first or quarter hour of staff time in responding to a request. And when you look at this other section under 204, when you're looking at different responses to the request, that's where you see approve a request and provide a record, deny a request, or notify the requester that you couldn't find the record. So I don't read section 203 as restricting the fees to only when a record is provided. And I think that, also looking at that legislative change last year, I don't think that would be the legislative intent when we're talking about balancing governmental entities and the burden this takes for them to do these, very thorough searches. I guess if it was narrowed to only sort of, like we're talking about in 2A, like compiling something in a different form, then if we were to look at it in this restrictive way, let's just say, excuse me, someone made a request for something that took like 4 hours, and then the government entity could just pull it, didn't have to compile it, reformat it, anything like that. Then that reading would restrict the government entity from charging for any of that search time, which I don't think is reasonable or the intent here. I don't think this is meant to limit those, except those specific prohibitions under subsection 5.
I want to also ask about we're on the posting itself and whether it may have happened. Is it the university's policy that a promotion would be posted internally? And if, so that there should be a record of it. I understand that a reasonable search has been done, you haven't found a record.
Yeah.
But it's the policy that it should have been. So
So
it's a reasonable request to ask for that record.
So I'm not as familiar with all of the nuances for when the policies would require something to be posted. I can see here in what the petitioners provided that there's a specific exception already for when something has to be posted when it's internal to the department.
3 days, it says on intern.
Okay, so I guess I'd like to answer your question more thoroughly, but what I know from this grandma request is that we did search HR thoroughly and there was no job posting, and we also reached out to Campus Recreation and they couldn't find anything like that either. So I don't agree that we violated any policy or any state law, those allegations. But I don't have all of the specific, what HR has informed me is that if there's some sort of internal promotion or internal working job title change, that is not required to be posted.
I guess that's what I'm trying to, I'm not, because whether the university violated policy isn't our purview, but more in my mind of whether the request was reasonable and how much time it should have taken,
Sure.
given what the policy was.
Oh,
and
sure,
what
yeah.
the fees should have been, given what the policy was.
Yeah, and
So that's where my question is going.
yeah,
Not to whether you follow policy.
right.
So,
Did I answer?
yes, yes. you
Okay.
Any other questions? Okay, Mr. Cooperstein, you have 5 minutes.
Okay, well, first of all, back to the fees, as Ms. Bradway just read. Often you can even review a record for free that's already been researched and compiled for you. I'm just asking to have fees waived for a search that yielded nothing and a search that I think is horribly overstated in terms of how much work that it took. First of all, she states that 2 HR people worked on it. The affidavit I received said only 1 person worked on it, and that was a sworn affidavit. So they were, I don't know, I know that she said that the government entity can charge for the first 15 minutes if I file 2 grammar requests within a close proximity of each other. This request was filed in 2020. The universities had 3 years to respond to this, 2.5 years to respond to this. And they issued me a letter of extension insinuating that they were doing some sort of detailed search that never happened. The affidavit that I received from the university said that the HR representative told 1 analyst to do a search and then called the campus recreation services and said, do you have any internal job postings that are responsive to this? It's a very cheap, quick search. And for her to say that they waived additional fees, does that mean that I was going to be charged over $50, more than $50, just asking the university to find a job posting? That is absolutely absurd. As for their statement that they tried to work with me through the ombudsman, it was not legitimate. They tried to offer me dropping the fees, basically to give the same bunk non-excuse that they just did. The job is required by university policy, and she should know that because she talked to the HR. It's required to have been, it doesn't matter if it was internal, external, nocturnal, it doesn't matter. Like the job, the university policies are clear, and if they didn't post the job, then something went wrong. Now, as for my position necessitating a job posting or whatever, my status changed at the university. First of all, I had to submit a cover letter and I competed against at least 1 other employee for the position. Second of all, there is a policy for this at the university too. If a new position is created and the position lasts for more than 9 months, which mine lasts for 4 years, and the position's more than 20 hours a week, which mine was, it has to be posted. There is no way around that. This like garbage about internal and whatever. Here's the thing. When I was fired from my position by the person that was actually put in charge of this records request, I was given a letter that said, I lost my job through a reduction in force. That meant that my job code, the one that she said, 3027, technical assistant, would have had to been removed from the university system for 1 year under state law. That's how a RIF works. My position not only wasn't removed from the position from the HR system, but almost a dozen people were able to apply for it after that. So that means that I was actually never promoted. Even though she's made that statement several times in this hearing, especially in her first presentation, she said that I received an internal promotion. I never actually was promoted. And my position that I held at the university was never actually deleted, even though the individual who was put in charge of this records request issued me a letter that said my position was deleted out of the university system. So, you know, I think this is pretty straightforward. Under every single policy and every law in Utah and every, employment law and every university policy guiding employment, my position needed to be publicly posted one way or another. When it was internal, external, doesn't matter. They can't produce the materials. All I asked for in exchange for not having this hearing was a reasonable explanation as to why they couldn't produce job posting materials. That was it. And I would have been happy not to have this hearing, and they refused to give me any sort of reasonable explanation. So I can accept that the records don't exist, but I think that if they don't exist, then that's more of an issue for the university unto itself, because it shows that the HR director was flagrantly willing to violate university policy. So that's all I have.
Yeah, thank you. I guess I'll just reiterate that I think there are a number of allegations being made that are not necessarily based in the truth. We did do a thorough search. Had a job posting existed, we would have been able to locate that quite quickly. I think as that's our typical process. We can locate it and provide it. We would have been happy to do so in this case. That wasn't the case because there was no job posting, which did require us to expend additional resources to sort of work through the request and why it made certain statements and sort of come to a conclusion for why there was no job posting here. So we unfortunately, we don't have records to provide. And so we would urge the committee to deny this appeal.
Thank you. Any questions for either party?
I have just one question. How many hours was the search done for?
Yeah, so this is an hour and 40 minutes or 45 minutes. I think it's an hour and 40.
Hour and 40?
Yeah.
And is it one staff member or was it 3 staff member? Because I kind of got different numbers here.
We have the search time for 3 staff members, but we did waive the search time for one of the staff members entirely. So the charge time was not the full hour and 40 minutes.
So you had brought up under 203. 203, that's it. 5C II previously submitted a separate request within a 10-day period. Was that the case with him?
Yes.
Okay, so he had submitted a records request 10 days prior to this one.
In 2020.
No responsive records were provided to him.
That's right.
For this particular request.
That's right.
Chair.
Any other questions? Comments? Motions? Deliberation?
As I do think there's been testimony to say that a reasonable search was done. I think that they did go above and beyond to perform a reasonable search. So I'm convinced there are no additional records. We might have some issues about the fee.
Do you want to split the motions? Do one for the record and then one for the fee? Or do something like that?
I think we can do it in the same motion.
All the same? Okay.
Yeah. Depending on how the deliberations go. Because I might be the only one that has issues with the fee.
I have issues too.
I have issues as well. And I think I'm glad you brought up the 203, the 203-1 and then 2A. I've never heard of just charging for a search. That's not what we ever taught. Yeah. So absolutely not.
It's interesting.
It is interesting. I think
It clearly says, and other direct administrative costs for complying with a request.
Yeah.
And further down, and 5C, responding to a request.
yeah, the responding to a request, that's interesting. Because the language is different, right?
No, the fee is $50.
It's just under 50.
It's the 48.
And that's, as she brought that up, that, it kind of conflicts each other on the actual cost of providing providing a record and compiling a record as in 1 and 2, and then responding to the request in 5 and complying with the request. It's kind of, yeah.
Maybe everybody's struggle, at least for maybe mine, respondent suggesting that they did extra work to do this request, but I definitely feel maybe like what you're suggesting. Having a hard time having somebody pay to not get their records, and just what I'm envisioning in my head of doing a search on a computer. And I think that that's what petitioner is suggesting. You're doing a search on a computer, it's happened in the past. Taking 1 minute to do a search to say that there is no job posting. I'm having a hard time understanding how you get an hour and a half of search time.
Because the
Hour and
policies
40
weren't
hour
filed.
40 minutes to do search for a job posting.
Well, I mean, that's why I asked the question about, is that the policy? Because if they had followed policy, they would have been able to come up with that and probably not even charged a fee.
Yeah.
But they didn't follow their own policy. And so they had to do a more thorough search, and now they're charging a fee.
But we have no jurisdiction over them, their internal policy.
Yeah, I mean, I know that, but my point is the reasonableness of the fee.
And the
Determining,
reasonableness of the request.
So there, I think it should be considered the volume of requests. As long as we can make respond to complying with requests more and more difficult.
So what was referred to in this was 2 requests.
I choose one they didn't provide the records for.
Well, and
You're right.
if you choose the volume, we're only aware in this hearing of 2 requests. If there are others, it's outside the scope.
the university in their brief said they've had over 200 from this individual.
So,
I do want to throw one other piece into this. Because Mr. Cooperstein is claiming, and it's true, he didn't get a record. But he certainly got a lot of information out of this request, in the sense that there was something funny going on.
Oh, yeah, I found out my job was never eliminated.
So the argument that he didn't get anything doesn't really hold sway.
well, yes, defining anything. You did not get the record.
Yes.
Well, because there wasn't one.
Yeah.
That's, it wasn't a record.
And I believe there wasn't, whether there should have been or not, doesn't matter. But I guess I just look at. I don't want fees to be, and this is a personal opinion, right? This is not to be thank you. I'm trying to think of the right word. A deterrent to providing records, I mean, we look at the reasonableness and almost every case we've ever had has always been, yes, we have records. And this is what's gonna cost to produce them, right? But also, and I'm arguing against myself here. It says that a governmental entity, and I just bring this up because I know it's under $50, but I think that's where it was about. Yeah. Sorry, I lost my train of thought. Give me just a second.
If it's over 50, they have to give a estimate, right?
Right.
That's the idea.
Well, they can, but it's before beginning the work. That's the part that before beginning the work, they assess the fee. Doesn't it say that?
Section 8.
Oh, it says, so under 8A, it says a governmental entity may require payment of past fees and future estimated fees before beginning to process a request. Now, it's kind of a different kind of arguing against myself because they processed the request, and I know that's talking about past fees and future estimated fees. I'm probably not I'm not describing it well, but it does. Like, we can charge, we can talk about fees before something actually happens. And if they can talk about fees before something actually happens, then maybe a fee for research is logical. I don't know if I can get there, but I'm trying to
I know
understand
if you
all
respond to
portions.
requests and you know that there's a cost.
Oh, yeah.
processing,
Listen, I just,
applying with requests.
I just reported my city council on records requests, this last week. And they asked me how much my time spent doing records requests was recouped. And it doesn't even come close to recouping the time that I'm taking to respond.
Okay.
So there is a cost to the entity, and when you have a voluminous number of requests, it is burdensome. And so I'm just trying to get past the actual cost of providing a record and compiling a record. I have a hard time getting past that in the code. So,
Grandma's conflicted, so.
yeah,
we
it
are
is.
too.
So we have to, so we get to interpret. Yeah, we get to interpret, because I get where they're coming in on the new statute too.
I think there is some wisdom in, I think the suggestion, no one's taking the order. There's a records question. And there's.
Yeah.
Separating them.
I do have to say that, despite my mantra, that this case seems different because, first of all, he hadn't ever had an experience of suddenly being told, oh, by the way, you owe us $50, you know, and so for him, the fee sort of comes out of nowhere. And I don't want to minimize that for him. We would have long debates if they did a search of 1,000, you know, and even provided one record and said, oh, by the way, you owe us $1,000. You know, the law specifically says you can't do that because it's
Yeah.
over 50. So, and to tell you the truth, they're saying, well, we didn't charge for the third person. Well, I didn't charge for the third person to keep it under $50. I think. So in this particular situation that I don't want to set a precedent for in the future, because I think we should require fee payment for just doing the research. I don't know, in this particular case, I'm going to argue that we deny the fee waiver. It's $48, but uphold and deny the appeal.
In this case, you're
Yeah,
A
I'm
grant.
right.
requesting records, and the
Yeah.
records don't exist.
Oh,
Yeah.
yeah, so yeah.
So there's just nothing to do there.
So what if we go ahead and do that motion, and get that out of the way, so we're all
I'll
saying,
suggest
yeah,
Can we do it as two motions?
yeah. Yes, we can. So I would make a motion to deny the portion of the appeal specific to the production of records, in that the entity did provided evidence that they did a reasonable search. Is that all it is?
Second from Ed. So we have a motion from Nancy. And a second from Ed. Deny that portion of the appeal. All in favor, say aye.
Right.
Now,
So you were saying deny the fee waiver? Like he's asking.
No, except, no, uphold the fee waiver. So that he doesn't have to pay the fee, whatever language.
Yeah.
that
Grant
produces.
the fee, grant the
Grant
fee.
the fee. Yeah, grant the fee waiver. Because in this particular situation, it just doesn't work. They've never done it before. They didn't have a record. They reduced the fee, so it'd be under $50. I mean, come on.
Run with that.
Okay. Did we get the language straight then? Did you get that?
Run with that. You're making a motion.
But so,
You can put it in the form of a motion, Reeve.
Okay.
the motion is to grant the
Grant,
appeal and the request for a fee waiver.
yeah.
Right. Okay. Grant the fee waiver. Grant the,
Based on the circumstances of this particular case.
yeah, based on the particular circumstances of this case.
you just, okay. The motion is to grant the fee waiver based on the circumstances of the case.
Change case to request.
Request, yeah. Okay, circumstances of the request.
Okay, read it back to us because we've all modified Marie's motion.
The motion is to grant the fee waiver based on the circumstances of the request. That's all it says.
Are you
second
comfortable with that?
Yes, I am.
Linda seconded. All in favor of that motion, please say aye.
Aye.
Aye. Any opposed?
Do we think that's too ambiguous?
The unique circumstances of this case.
You want to define
Well,
it.
it'll be, the reasoning will be in the reasons, the
Okay.
statement of reasons.
I just want to make sure we don't do. what
You want the
happened
motion to
before.
say.
Yeah, where we have
Because
to come back.
It's like, wait a minute, this doesn't work.
But you feel like
want the motion to say because. no record-
articulated the
Okay.
reasons.
I think it's
Clearly
efficient, that's my reasoning.
No.
You know, because I think what.
Do the explanation. of it.
Okay.
Committee feels like people in working situations where no records were provided or.
Yes.
Like not in this case.
Yes, thank you.
Right? Am I interpreting what we're saying right?
Yeah, and Brian says we can get the reasons, yeah, the order of the reasonings, still make sure that they articulate that.
So that motion carried unanimously.
Aye.
Now it carries
Any opposed?
unanimously.
No one's opposed. So we'd like to thank the parties for being here. The order will be reviewed and signed by the chair and then distributed to the executive secretary to all the parties within 7 business days. Either party may appeal to district court within 30 days of the date of the orders. So thank you.
Thank you, guys. And just for the record, I'd be happy to pay for any searches that come up with nothing, so long as like I don't have to pay for extra stuff because they didn't follow their own policies. So if it's a reasonable fee, I'm good. All right. Thank you. See you in June.
Madam Secretary, we will break for lunch.
Yes. Motion to take a break for lunch.
Thank you, Nancy. All in favor, say aye.
Aye. SRC case that.
All right, we're recording. I got a message from Mr. Eames that he's pumping water out of his basement, so he will not be attending. Which was probably, and then I got an email a minute ago from the record officer in Logan who said that she just received a new request, so she doesn't think he's very busy.
Okay. So the respondent is here.
Yep.
That has made the effort to come down from Logan.
Yeah, I've been here all day.
Is the committee comfortable moving forward without Mr. Eames being here? Is that a yes from everyone?
I am.
I am, yeah.
Yes.
Okay.
I know, it's not a complicated
I
case.
suppose then we move forward, call the meeting back into session. And we move forward with the next item on the agenda, which is Brady Eames versus Logan City. It's hearing 2022-190 and Mr. Eames is requesting a fee waiver. We've had an opportunity to review the material before the meeting. So if you're ready, we'll just go right to the respondent.
Yeah.
And will you introduce yourself?
Yeah, Mohammed Abdullahi, Assistant City Attorney for Logan City. Like you guys said, this is not a complicated case. It's pretty simple. This is actually essentially the exact same case as you heard in September of 2022 for the fee waiver. Exact same argument. All he did is, and I mean verbatim, all he did is he took out UAMPS contracts, put in Emporium contracts, and the amount is different, which was $100 and some odd for the UAMPS. Now it's $52 for this request. The one wrinkle is that Mr. Eames put in another request on February 27th after he was well aware of how much these documents cost. It wasn't a surprise to him. And he requested essentially the exact same documents. Because we had to prepare for this hearing, we got the documents ready. We gave it to him on Monday. So he's got the documents and he owes the $52 whenever he can pay. And he'll be required to pay before he receives any more documents from Logan City.
Any questions for the respondent?
So you've done the work, prepared the documents, and it was still just $52.
Have there been any redactions?
No,
Go, Nancy. I saw you almost say it.
I'd move to deny the appeal for a fee waiver. Actually, before we move, I should ask you, would you tell me how you came to the fee?
yeah, so the finance department, it took about 3 different individuals to compile this request at $15 an hour. And this is the document. That's how we got it. It was 3.5 hours, $15 an hour, $2.50.
That's pretty reasonable, $15 an hour. That's
I
more
think so.
reasonable than our.
I think so. And that was including the finance director's time, which obviously is more than $15 an hour, but we're supposed to charge the lowest paid employees wages who can complete the search.
And he got copies of all those records in that file.
He's got everything via email as of Monday.
Right, I would move to deny the appeal for fee waiver. In accordance with 63G2-203, the city may charge fees for the compiling of records. And the fees are reasonable.
I'll second it.
We have a motion from Nancy and a second from Marie. Any discussion to the motion? Hearing none, all in favor, say aye.
Aye.
Aye. Any opposed? That motion carries unanimously. So the order will be reviewed and signed by the chair and then distributed by the executive secretary to all the parties within 7 business days. And then either party may appeal to district court within 30 days of the date on the order. So thank you.
Thank you.
Appreciate your time.
It came a long way for very short.
But I thought it was important that I was here and for the committee to be able to see exactly how much he requested, so.
Thank you.
And I appreciate seeing that.
And I want it on record, even if it's just on the recording. That what the cost was today with your salary, having to come down from Logan. And all of this. And these are records requests that he is just repeatedly submitting and just changing small things in about who. I just want us all to be aware of the cost, the hidden costs of all of this.
Well, the fact that he has received the records and hasn't paid the fee yet, that's important to know.
There's also another appeal that's gonna be before you in June for essentially the exact same thing. So forewarning. That one's a $30 fee. It's the only difference.
Thank you. Okay.
Maybe we should address that in our rules when we start talking about it.
Okay, thank you. So now we'll move on to the business portion of the meeting. Give him- For just a second.
Okay. The business part of the meeting.
Yeah, I do.
Will
you give her
We
this?
have the minutes
Her
for
and
February
has been my
2020.
mentors in college, and I would really like a meeting with her.
Next time I see her, I'm sorry, yes, sir.
Second. Second by Nova, all in favor?
Next time I see her, I'll get special.
Okay.
She did swing by my office yesterday, but she's not in every day.
Yeah.
When I see her, I won't get a
Second
chance
to
to.
approve the minutes for February 2020. All in favor? Aye. Any opposed? And Marie is abstained. Business, we need to address order 23-07 Brady Eames and Utah State Treasurer. Do I have a motion? Do you want me to give any more detail? Is that?
Up to you guys.
Can't try me.
Okay. We were talking about that, how to interpret that section, and it's always been very difficult.
There's 2A is the main section. There's all the
Order
subsections of 2A.
23-07, which is Brady Eames.
Okay. Try to look at it. Thanks for clearing that message for me.
No worries.
Is there a second?
Second.
That's first by Nova, a second by Ed. All in favor? Aye.
Aye.
Any opposed?
The motion carries unanimous.
Thank you, Nancy.
That was the order one.
Okay, legislative update.
Okay. We had. The bills, hang on. Just, So part 6 of grandma became a big deal this legislative session. Archives have been getting a lot of questions about it because the privacy bill has. It's specific to state departments, but part 6 of grandma applies to all government agencies. Right, so the archives was getting a lot of questions, and so record officers are more aware of part 6 and would like to comply. And state departments need to provide the archives with a privacy annotation, which has a definition in this bill for every record series to essentially explain what personal information they're gathering and what it's for. So that's kind of a new element for records management for state entities. And HB 21, which was originally for any public body, I don't think that one's going to apply to us anymore. So the big one is Senate Bill 231. It's called Grandma Amendments. Everybody calls it vexatious bill. It adds new sections, grandma. It adds a 209, which is all about vexatious requesters and a new type of hearing that will be coming to the State Records Committee, where the governmental entity is the petitioner asking for relief from a requester who is now the respondent. And so that verbiage is gonna get mixed up in my head for a while. There is a list of things that the committee needs to consider, so they have those hearings. And so one of them is the legislative intent and how many requests are coming in, but not just the record request, but also other behavioral correspondence that may be considered an abuse of the right to access records. And so that's Senate Bill 231, and the end of it, the end of this section for 209 says that the committee shall make rules to implement this section. And this bill is going into effect in May. So Brian has put together some rules to help get the conversation started. That includes a new section for vexatious requesters. There's not a lot there because it's kind of up to you guys if you want to add what kind of rules you want to add. But we're gonna add all of our changes together and try and get everything through as fast as we can. And hopefully we'll have it in effect by May 2nd, maybe not, but that's okay. We'll be working on it, right? And
Is that the one about what defined a reasonable search?
it does define a reasonable search. It's a circular definition.
Yeah.
But it does
Yes,
define
yes,
a
it
reasonable
is.
search. Yes, it also says that for judicial review, that parties cannot bring up in judicial review something that they did not bring up to the committee. So I think we might, I don't know if that means we'll see more of people saying, just to protect my ability to address this in court, I need to say this, even though it's not specific about records. I don't know how that's going to influence how people present to the committee.
It will influence on how I write orders moving forward. I will include now a section of issues where it clearly outlines for the court what the issues were that the committee heard. That way it kind of frames it a little bit tighter for the court upon review. So I figured we might as well just start that right away. It makes sense to keep it neat and tidy moving forward.
And there was one other thing about business confidentiality that was added in 231. It says a person who makes a claim of business confidentiality shall protect, defend, and indemnify the governmental entity that retains the record and all staff and employees of the governmental entity from and against any claims, liability, or damages resulting from or arising from a denial of access to the record as a protected record based on a claim of business confidentiality. I wonder if that's a direct result of the big game appeal. But so that's now in grandma.
Do you, I don't think that that would relieve the governmental entity from assessing whether. Do you think that means that if they say it, this portion is business confidentiality, we're just gonna take it at face value? Or would a records officer still need to make that judgment themselves? I wonder.
I think the records officer still has to act.
Yeah, to me, that's how I would take it. I just wondered how anyone else.
And if Big Game was the driver, that would
Yeah.
really the records officer, in my opinion, lost track of it as it went on.
Yeah,
And
yeah.
then came back saying, that's still your responsibility. These are your records.
Okay.
They're making their way through the process. You don't just get to wash your hands of it.
Yeah.
If that makes sense.
Yeah, no, that makes sense, yeah, because I would still want that, like, I would still want to know that I had looked at it and said. Yeah, I don't know, it's confidential about this, you're gonna have to explain it further to me. You know,
There was also an update on how grandma applies to the governor's office and the lieutenant governor's office. And I think there weren't many additions to 305. Usually every legislative session that list grows of protected records. I think there may be two, maybe three, but there weren't a lot added this year.
And that made sense. I can't remember what they were, but it made perfect sense that they were being added.
Yeah. So the big takeaway is really that we need to update our rules quickly. So I've put everything. All the changes and suggestions that have been made so far are in that document, but it's kind of hard to read. So I did email everyone the latest draft that's a little cleaner and easier to read that Brian put together. So if you want to go through that and make some comments, send it back, we're gonna start compiling what people could be there, changes that should be made and get that ball moving.
We'll be engaging directly with the Division of Administrative Rules. The first time I've ever found. I should be getting the end scraps. Correctly.
Now, does the new bill about vexatious requesters identify what that means? So we have some.
Vexatious is not defined. At the hearings, they kept saying that it's something you know when you see it.
yeah, I watched that. That's-
The bill does give an outline of what you need to look for or consider. And that's kind of the main guidance is what are the main issues you're considering of what a vexatious requester is. And like she said, she named off a couple, the behavior of the correspondence, the tone of the correspondence, how many requests they've made. The bill does kind of give some guidance.
Okay. It didn't limit what the committee decided. In appropriate consequence, I guess is the word. You do have the option of declaring them vexatious and the governmental entity doesn't have to respond to requests for a certain amount of time determined by you, no longer than a year. It doesn't say what happens to the requests in the queue during that time. So
is that something you would decide request by request, or do you think
You
we
could,
determine guidelines?
I don't know if that's something the committee could add by rule or something you would want to address on a case by case basis.
We don't know the answer to that question yet.
But it only gets to us if a governmental entity declares them vexatious.
The governmental entity asks you guys to agree with that they are
Yes,
vexatious.
okay.
Yeah,
So.
yeah. And my understanding is that this will be on an entity by entity basis. So for each requester, if there are multiple entities that considers a single individual vexatious, they would each have to appeal, is my understanding.
Couldn't all just group them together.
Correct.
What you'll notice in the bill draft or not the bill draft, the rule draft that I gave to Rebecca, I did have a rule stating that a vexatious requester hearing is for a closed hearing, not publicly open. My reason that I put that is I thought it made sense under OPMA, because OPMA does allow a body to close a meeting for discussing someone's character and, you know, their overall kind of character of self. And I think that as we get into vexatious arguments, I think there's prone to be that issue come up. And plus, I think you're affecting people's rights on records requests. I think that is kind of a closed session type of ordeal. So you'll see that language there. Again, like I echo Rebecca, my draft is just to get the conversation started. You know, it's to give you guys something to start working on. Ultimately, it's up to you. I really don't, as you've noticed, chime in much on order drafts or revisions once they're posted and for you guys to review. It's, you know, they're your babies at that point, but you'll see that language. That's the reason behind it.
So I'm wondering if for a vexatious hearing, if we should not schedule that separately from a regular hearing. I envision it being a longer process for us than,
Thought about that. I thought maybe you could do it at the end of the day as the very last hearing. I know you all are volunteers, so taking another day to come for a separate hearing might be an issue, but
Do it electronically on a different day.
yeah, so it's kind of.
You also want to decide kind of how you want to schedule these, because the bill does say that it can be scheduled out if there are already 10 appeals scheduled, and then so you can schedule it for the next month. But are appeals for record access the same as an appeal wanting someone vexatious, right?
yeah,
Or
I would claim they're very different.
I think they're different. And I'm just wondering, we get kind of tied around a pole on some of these hearings we last 2-3 hours on.
Doesn't the bill say that it has to be on the regular scheduled meeting though?
It
Yeah.
does, yeah.
That's why I was thinking maybe it's just the last hearing of the day and clear everybody out for a closed session.
Well, and we might, maybe we won't get very many, right? Maybe we will, maybe we won't. We won't know until we experience it. I mean, if we're getting a lot, we may have to do additional.
I think you'll get a few at
Yeah,
first.
yeah, I think we will. And then I think it'll probably settle down a little bit.
Yeah, I mean, vexatious is, we all like that word because we know what we've seen. But then when you start to kind of put the ethics behind it,
Yeah.
you're like, wait a minute here. And it's a little bit more touchy than just saying you're vexatious.
Yeah.
It's interesting, just we had a court case, where I work, associated with an individual who the court ruled vexatious in this records case. And the interesting part about it was like, I thought the judge put up with a lot, and it wasn't until the individual started attacking the judge personally. And then he slapped him with it. And so, yeah, and trying to keep it not personal, but trying to just, to the facts and stuff. So we'll have to just maybe see how. It's an uncomfortable position. Yeah, it is. Yes, it is. To deny anyone's right to records.
And on that point, I was kind of telling Ken, my belief is it does grant you guys more power, more legal power. You're now affecting somebody's ability to request records for a certain period of time. Just that alone, I think it makes it even more important to make sure we have the procedures of a hearing really nailed down. So you'll see in the rules section, I tied it up to no overall procedures for the hearing and, so it follows cleanly, but, for what it's worth.
Exciting time to be on the committee.
So do you envision that the person would be in that meeting?
Yes,
Or-
I'm sure that.
Yeah.
Want to be here.
So, so there would be the governmental entity and then that person to try and make a case for why.
To that point, but then the deliberation part.
Yeah.
Yeah, so that's the other thing is I put it in the rules that, because this is such a serious issue, you will release an order within a week. And you can close the session down and deliberate for a week and do an order in private. And then you can reconvene to issue the motion and the vote and release the order at that time. That's kind of how I've set it up.
But the
We could reconvene electronically.
Right. Interacting with the respondent and petitioner at one time after you
It would be the
close it,
hearing, yeah.
and we move to deliberate, come up with an order. They're no longer.
Reconvene, and you could do it electronically with your public notice, you know, and re-engage with the parties at that point.
But do we have to re-engage with parties at that?
No,
point?
you can just come back and issue the.
That's what I meant. It's like, we don't need to re-engage. They just
Right.
need to be aware.
You can just issue this order.
That's essentially what the court does. That you just come back, receive the.
I think it's great for you guys to do it that way. That's kind of why I threw it in the rules. It allows you some time to, I mean, I think you're gonna have some heated hearings, honestly. Allow you to calm down and gather the facts, look over the arguments, think about it for a few days, and then, you know, get an order prepared and reconvene.
That's the one part of the legislation that I like how it's written, because I think we can come up with a list of criteria. And if an individual meets most of those criteria, we can decide.
Yeah.
Indeed, you are vexatious. Here's the penalty, and it can be up to a year. But we can adjust that accordingly to the situation. That gives us some flexibility that way. The other part of it that I do feel like is lacking, and maybe, I don't know if rule can cover this, but if somebody's been declared a vexatious requester for a year, they could, in that year's time, have a reason, a very legitimate reason, personal reason to get a record. Then what do we do then? Like, you just can't approach the government for something that really protects your rights as a citizen.
That's an interesting thought.
It's just a danger I see where.
Yeah, because I was
Doesn't the
thinking,
court have, sometimes if someone's declared vexatious, or
they have to do it through
submit an appeal.
They can go judicial review of the vexatious requester order. Yep, but the bill, I mean, to Ken's point, is kind of silent on
It is silent.
what happens in the interim. Let's say they don't appeal to court, so now there's just a vexatious requester, and we got a legitimate request. Can they appeal the denial of that? Yes, but
Or while they're a vexatious requester, they just follow the
well,
court
you
route
know, when
discovery.
we have that, I declared vexatious, the court put a procedure for them if they needed access to the court, it had to be done a certain way.
That would.
And what I think it was, it had to be an attorney, for them in the court, it had to be an attorney that did it, not a pro se. That petitioned the court to allow this case to be filed, right? So maybe there's a way to,
you could adopt that by rule.
yeah, petition the SRC to allow a records request to be,
An exemption. or a-
yeah.
an
So you
exception.
guys could form a committee within to take a look at those.
Yeah, maybe could we by rule say like the chair and 2 members or something? review?
Yeah.
I don't know. These were just things, as you're going through that legislative process, you just don't think of all of the nuances.
Yeah.
Because you're right, that is how the courts handle it. You know,
Yeah.
they do have to get court permission to file a suit. So if you're a vexatious requester, and it was in the debates, you know, they talked about the analogy of the court vexatious litigant. Maybe there's a parallel there to, you know, make sure requests are legitimate. I don't know, but yeah, I think because there's nothing addressed by statute, then yes, you could address it by rule.
That's usually the position if the statute's lacking. You want to have rule and procedure. Make sure that it's clear.
But with that said, I mean, the prerogative behind the rule was to relieve the SRC really of hearing so many appeals. Now you're just getting these petitions for new requests.
Like, can we put in the rules so we can decide whether or not to hear the request?
Oh, yeah, yeah, that's the.
Yeah,
the precedent.
because we could just read through it. And not decide not to take the committee's time.
Yeah. It grants us a power, an amount of power we're not used to having.
Yeah.
Yeah. And so.
Give it an administrative review, yeah.
And that might be a good thought, just like you do with the declining hearings, the three people meet, collaborate over this petition. Issue a decision of whether it's a legitimate.
Everybody's really thoughtful on their response, and we always have reasons to grant or deny. Not follow a similar procedure.
Yeah.
Similar
I like that.
oversight.
Yeah.
And if you wanted, we could have the whole committee chime in. We're comfortable with that too. It's just, we just do a member, the secretary that runs it, the chair and another committee member respond, and we rotate that. That works great. If not,
I would feel better to have a full quorum or vexatious.
I think it's great.
Vexatious hearings, it does require a vote from the entire committee, whether. So the secretary, the chair, and one other member can deny the appeal for a vexatious request or hearing. But then the entire committee has to vote at the next meeting to uphold that or not. That is in the bill.
Cover your concern, or are you thinking of the
I'm
initial review?
The initial review.
I mean,
I just think
we
it's
can-
very sensitive.
I think
really
we can
do.
try that. We can always change the rule.
Yeah, well, if we can read what we've got here and then we can just make comments and filter through it.
Good stuff. It's in the life of grandma.
Are we gonna wear gowns?
Yeah.
Yeah, and I need wigs.
Wigs?
And a mallet.
Grandma things kind of peak and then settle down and peak, settle down. And it's usually a 10-year cycle. So,
Wigs, that'd be cool.
okay, I'm gonna lower your per diem. Okay. Anything else on legislative updates, Rebecca?
Nope, I think that's plenty.
Okay. How about SR appeals received and declined, notices of compliance and related action items?
Yes, let me share my screen. Maybe. Here we go. Okay. So I did receive a notice of compliance from Granite District for the Bagley appeal. I do expect to receive something from Bagley's that they are appealing to district court. They're still not convinced that they have received everything. We have 3 appeals that have been denied since we met last. One is Brady Eames versus Miller County. Can't really read that. Can you? Okay. So this one, he is requesting access to records related to a murder investigation from 1989. And the committee has heard this before, and in order 2104, the committee had determined that Miller County had provided access to everything already, and he they have provided access to all public records responsive to Mr. Ames' record request, and so that one's been denied. Eric Peterson from the Utah Investigative Journalism Project versus Utah Admin Port Authority. This one is a request for records related to benefits to one board member. This was denied because the respondent said records do not exist, and there wasn't sufficient evidence provided that the records do exist. And then Stephen Allen versus the Department of Corrections, he was requesting a warden variance from 1993. And it was initially incomplete, and the record officer at corrections is fantastic and provided everything else to me, so we didn't have to wait for it to come to mail. But that one was also denied because sufficient evidence was not provided that the responsive records exist. It sounds like because it's from 1993, it's a financial record that's come and gone, but the CAO did provide the request with information on how we can get a new one. That was helpful. And then we have 2 incomplete appeals that might get completed, maybe not. And then 3 appeals have been withdrawn. And I don't know how many are going to be getting withdrawn going forward without an ombudsman. So I have 21 appeals scheduled for next month. And we are scheduled up in June. Going the wrong direction, I'm going the wrong direction. So
It's the Brady Eames that we're hearing in June, as you mentioned.
that one is for a fee waiver. He was requesting access to records related to a building called the Emporium being sold and torn down or something. And so there are fees for it. They provided the records and so there's a fee. And so he's asking for a waiver, the fee to be waived.
Like what we did today. Can't we then deny this one?
Yeah. Brian, well, it was scheduled for June, because that's when appeals are being scheduled for. So I don't know if we can actually pull that to this month and sit and have a motion without letting the petitioner know that the committee's hearing the appeal right now. But I don't know, what do you say, Brian?
What exactly is the question?
The question is whether the Brady Eames versus Logan City appeal scheduled for June, that is the same issue that we just heard, can be addressed right now.
It's different record, but still.
Different records, but it's the same issue.
Even though it's the same issue, it's a totally different request, right?
Right.
Yeah.
So we have a second come back to us and say, we're not budget.
So we've got 1, 2, 3, 4, 5 hearings scheduled, but 6 appeals, because KSL and Salt Lake City have already said they're willing to have the 2 requests heard as 1 hearing, so each request has its own appeal number, but I put on the same line because it's going to be 1 hearing. And I sent them 1 letter that has both numbers on it, so it's consolidating where we can. Any questions?
I was just gonna say that we haven't had very many appeals.
No, that's
No,
26 so far.
From the press.
Oh, from the
I
press.
saw Fox 13 up there.
You know, yeah, we have Fox 13, we have KSL, and I think we still have the UTV. And then there's another KSL for June and April. Yeah, that's it. Not many from the media.
So the election one is still not done in court.
It's still in court. Yeah.
So let me ask you a question about Brady Eames again. I'm not asking that we take action on it. I'm asking, why can't we deny hearing the appeal?
Our administrative rules is specific to the request. So even though the arguments would be the same and the committee's decision would be the same, it has to be the same references. Yeah.
Oh, I see.
For us to deny it saying we've already heard this.
Okay.
Shut my notes. What's next? Yes.
Court cases.
Court cases.
1 is dropped for sure. William Sherritt, v. Board of Pardons and Parole. That is now, the board has prevailed, State Record Committee prevailed, so that the judge ruled on that. We got the decision yesterday, 2 days ago. And then there's going to be 2 more that are likely going to drop as well. I filed a motion on Benyon to drop that one because the AGO's office has been dropped from it. So there's no reason for the State Records Committee to remain. And then there was a Heber City v. Larson, David Larson, that case. That the attorney for Heber City has pushed that to get a decision from the judge. So I think those 2 will likely be dropping here pretty soon. But that's the only ones that have been disposed of for potentially. And I have not seen any judicial appeals for a while now. So,
That mean we're doing a better job.
yeah,
I'm just kidding.
means you got better orders.
See, he is a good guy.
Yeah.
Because you got some fine orders.
We won't let him. There it is. Okay, good. Glad it slowed down a little bit.
Yeah.
All right, Rebecca.
I have one question, if you don't mind. We're hearing more and more this concern over the AG office representing state records and representing all the things. And at least I'm hearing it more. Do you think there's gonna be something rise?
Because it's set by statute.
Yeah.
So it's not like the state records committee has retained the AGO, privately. The legislature has declared that. So if there's a conflict, I mean, honestly, I don't know how a court would reconcile that because that's what the legislature wanted.
Are committees like this ever represented by private counsel?
Not that I know of. I mean, it is not uncommon to go out and get counsel for litigation, entities and agencies get that all the time. They'll farm out their litigation, but just in-house general counsel type of work, I mean, it's very common, so.
Clear in our statute that archives provides the support for the committee and the secretary, and we are represented by the attorney general.
So what are these guys who are raising this issue hope to happen? Nothing, they just wanna have it on the record.
They've worked for the attorney general's office.
It's just they're preserving an objection for court and they'll raise that argument in court and who knows what will happen there, but.
Yeah, okay.
All right, either way, we have to have legal counsel.
Yeah.
Right?
Yeah, I'm just wondering where it's going, or where it's leading to.
Yeah, it's a theme that's been ever present.
Yeah.
We like the AG. Our counsel, he's a fine guy. Hey, Rebecca.
It was probably.
Hold the community. The committee.
The committee's next meeting is April 20th. Will you be here?
Depends on how many.
How many things we have on the
If there's
agenda?
21,
Well,
I'm not gonna be here.
we have 21 there, but we're not going to hear them all. We're gonna hear 4 or 5, maybe 6. I always try to put a couple more on the agenda in hopes that helps the parties feel encouraged to resolve the appeal so they don't have to come. And sometimes one doesn't drop off, but I was expecting us to have 4 today instead of 5, and it didn't work out the way I was hoping. But we'll have 4 or 5.
Good, because it's only 2:30.
Yeah, we did all right today.
Yeah.
I will be out of town, but I think I can participate electronically.
Okay. Be here.
I'll be here.
I'll be here. Ask me this evening.
Details at once. That would not be.
And we need
Okay,
Nancy.
sounds like we'll have a
we
call.
need Nancy to
I'm
be here for
peeling
one
from my
hearing.
sunburn.
Yes, Nancy needs to be here for at least 2 hours.
Did she?
Oh, you're not gonna be
Did
here?
she warn you?
No.
I need you
You're not for a long rest.
to chair one hearing. And Jim will be,
Is it-
Jim could just
I was
be at
gonna
my
say,
meeting.
is it the one that you have a conflict with, or you won't be here?
I need to go present.
He's a
to them.
medium.
Oh, are you going to Armin?
I'm not going.
I'm the presenter. Showing them on the archives.
I thought it was a tour, yeah.
Okay, I
I'm
just,
gonna run to the archives building and run back. So can you chair
Yeah.
or, and we can.
can I pick which order you put in that slot?
Yeah.
Which you
We figured it would be one hearing and then go on to business.
So.
You're the chair. of all the business. Yeah, to do business. So, I come back, there's nothing on the agenda. For 2 hours. Order pizza. I know.
We're good.
Thank you. Are we good? Do we have a quorum?
Yes, we will have a quorum.
And yeah, I may have to do electronically that day. So
Okay, I'm looking for a final motion.
Motion to adjourn.
All in
I-
favor?
Forgot to let you make one.
All in favor, say aye. I'm sure no one's opposed.
Just to sign that. But I'm not going to.
Turn off that recording.